Right. Give it a couple more minutes, maybe a minute or two, and we'll get started. Can everybody hear me okay?
Yep.
Yes, for sure.
Yep,
Oh,
still.
okay, good. All right. Thank you. All right. And everybody can see my screen okay. I'm working with the new system, so I'm hoping to get it right here. We'll be opening it up at the end of the presentation for questions. So it's kind of a long presentation this time, a little bit different format, but you got a notebook and pen, and there should be a lot of good information, and notes are encouraged. So are questions at the end. All right. So I'm not sure. And yeah, if you could keep your microphones off until I open it up for questions, that'd be great. And I am going to try and work the slides here. All right. So before we get going, I just want to say thank you, everyone, for showing up. My name is Dave Horowitz. I want to thank each of you for taking your time out of your evening to be here. So in just a couple minutes, I just wanted to give a brief introduction. Haven't really gone into this in any of my other seminars, but basically wanted to go into why I've spent basically the last 4 decades studying law and commerce and finance and trusts and business and scripture. And basically back in 1987, my brother got a 4.5-year prison sentence, basically in a case that changed how I look at the world. At the same time, growing up in New York, I saw all kinds of corruption firsthand: power, money, business, organized crime, public officials, and they don't always operate in separate worlds. Most people think, the good guys and the bad guys. I've seen it firsthand where there's not much difference there. So ever since then, I've basically been trying to search out truth, find out what's real, because what I was told as a kid is not what I, came to find out as truth. So basically, what is true, and that question led me to the study of law in all kinds of forms: constitution, equity, trusts, commercial law, international law, anything that I could get my hands on, jurisprudence, commerce, the law merchant, right? So, and in 1989, I started studying the Bible as well. And that I found a whole different body of principles dealing with the same things that you deal with out in the main, in the world we see outside our door every day, right? So scripture has, deals with stewardship, justice, covenants or agreements, contracts, right? Inheritances and administration. So way back when, 89, I became a certified financial planner. I worked as a private investigator for years, specialized in finding out information and people who didn't want to be found. I built numerous and operated numerous businesses, and set up a limousine a limousine company that's still running 40 years ago, that I set up 40 years ago, and it's still going. Basically, after studying all these different things over the last 40 years, commerce, as far as the law of commerce, organizations, systems, and how do they work? When I look at things, I kind of like to reverse engineer. How does it work? Not just, the functionality and where does it get its power from, right? So every single thing that I was looking at in the system, whether it be business and law, all these things are just little cogs in the overall system, same system. And 15 years ago, I began organizing everything I'd learned into what I call the Kingdom of Heaven Trust Management System. Okay. It's a system. It was designed to be able to set you apart from, or to help you set yourself apart from systems of outside control in a way that is legally and lawfully recognized and defendable in pretty much any jurisdiction. But we'll get into that. That's just want to, cover a little bit about how the Kingdom of Heaven Trust Management System came to be. So, not here to tell you what to think. I'm here to challenge you to think a lot more deeply than you ever did before about commerce, stewardship, and administration. And hopefully by the end of tonight, you'll begin asking better questions than before you get exposed to this information. So we'll get started. So commerce, before we get into debt, okay, before we discuss anything about credit or negotiable instruments, let's get into defining what commerce is, okay? Most people believe commerce is the buying and selling of goods and services. And that's part of it. And it's a bit incomplete, right? So commerce, I'd say the shortest way that I would define it is the ordered exchange of value between parties. Okay? It can be public commerce, and it can be private commerce. But whenever two parties voluntarily exchange labor, property, promises, services, obligation, that's commerce. Okay, that's where commerce exists. And it was around long before, governments started minting coins and banks started, running their fiat currencies. And anyway, commerce has been around, okay? Trade has been around forever, okay? Born out of relationships, not currency. Okay? Same way trust is developed, interestingly enough. But money, currency, it's just tools. These are tools of commerce. That's not what commerce is, okay? Commerce is older than the nations and all of the laws. In antiquity to today, same. It's older than it all. There's always been commerce, okay? A trade between people, okay? It is as old as mankind. So we're not studying financial instruments by themselves, as independent concepts, okay? But I do want to uncover the architecture that allows this all to function, okay, how commerce functions. Okay, and once you understand what commerce truly is, the next question becomes obvious, okay? Why do few people ever learn how it actually works? So, why does this seminar exist? The greatest advantage with any system belongs to the person who understands the system most people participate in commerce every single day. They never study about, the structure of it. How do the parts work? How does it, how does it all interact and fit together? They borrow, they lend, they sign agreements, payments for this, that, and the other, right? And nobody stops to ask themselves, why do these mechanisms exist, or how do they all fit together? Okay? Ignorance does not prevent participation, and they count on it. Okay? It just simply prevents wise administration. Okay? Ignorance, you can participate. They hope that you're ignorant because it's very easy to get taken advantage of in commerce. Okay? So my purpose isn't to convince you that, any particular financial philosophy, that is not what my purpose is here tonight. But it is to expose the underlying principles that govern commercial relationships so that you can make much better decisions from understanding them rather than, having to figure it out when it's too late or that you already have a problem. And hopefully you'll learn something new here tonight. So most people believe they enter commerce only when they buy something. And in reality, commerce surrounds nearly every single decision people make. Employment, renting property, borrowing, banking, insurance, signing any contract. It's commerce. Even choosing not to act often has commercial consequences, right? Oh, I wish I'd bought that stock way back when, or, bought that property, or, made some other decision, right? And then we blame that throughout our life. But, commerce isn't an occasional event. It's something that is, any society with, a couple of little tribes interacting, okay? It's the framework which modern societies allocate labor, resources, obligations, and risks, okay? Because commerce is continuous, ignorance within commerce becomes extraordinarily expensive. Anybody who's had credit problems understands that. Okay? So if commerce is this pervasive, it's everywhere, right? Why doesn't anybody understand it? Really understand it? So, and I want to say it again. Ignorance in commerce is expensive, very, very expensive. People who have bad credit pay higher fees, right? It's the one that is ignorant to the system and how it works, not really understanding all the ins and outs, that gets taken advantage of by it. But, they do depend on that. So, you go to school, they teach math, science, history. They don't teach you about debt. They don't teach you about credit. They don't teach you about negotiable instruments and security interests and commercial obligations, right? So if you don't understand it, they don't teach you about it. And that very first thing that you get the day you turned 18 was a credit card offer in the mail, right? The results are predictable, how that's going to start out. People become skilled workers, right? And I've met doctors, I've had clients that were doctors that couldn't, balance a checkbook. They had no idea why their business was failing. They had, they've been in surgery every day for years, but their business is failing. Okay, they sign documents that have legal and commercial consequences. Nobody ever reads the contract. They want the benefits. So ignorance in the system in commerce, it's not just a lack of information. The information's out there. There is a lot of lies. It's a hocus pocus industry. There's a lot of corruption within it. Okay, but ignorance transfers wealth. If you don't understand something, if you're ignorant of how things work, okay, you're transferring your wealth, things that should be within your estate, opportunities, okay, and control to those who have a greater understanding than you do. And that's why understanding commerce is not just useful, okay? It touches every area of your life. I teach trusts and that's great. Yes, I know how to protect money, but if you need a holistic picture of how this all works and fits together. Credit and debt, they're not necessarily bad, but they can be horrible. So commerce connects civilization, okay? It's not an isolated discipline. It connects everything about civilization, and that's not just in one country, it's international, right? Families depend on it, businesses, ministries, trusts, they administer property through commerce, investments, right? Investment firms, they allocate capital, real estate transfers, education is financed. Governments operate through commercial system, not just the one that you sit under, okay? And they all interact, and a lot of them have their own currencies and exchange values. And I'm not trying to get into all the ins and outs of the financial world. That's a different seminar, right? But when you understand commerce, all right, you're not understanding only how money moves, okay? You're learning how obligations move, how rights move, how value moves from one entity to another, whether it be a human entity or a legal entity, okay? Ultimately, how stewardship is exercised in the interconnected world, okay? And with that foundation established, you can now define exactly what the seminar is, okay? That's just as important as what it's not, okay? The seminar, okay, before we begin examining commercial instruments, we have to establish how we're going to look at all of this, right? Our method of study. So the seminar is not organized around financial products. It's organized around principles. I worked as a financial planner, and, when you work for your John Hancock's and your MetLife's and some of the bigger firms, all of the firms actually, they teach a very specific way to go in and discuss estate planning and retirement planning and insurance planning. And they've always got a product at the end of it that, is some sort of an insurance or financial product. Okay. That's not what this is about. Okay. This is about understanding how it all works together. Okay. Around principles. Okay. Because principles don't change when governments change, when currencies change. Okay. Principles don't change when the technologies change. So the commercial instruments we study are simple applications of deeper truths. Okay. The principles of obligation, exchange, documentation, administration, and stewardship. Okay. Our objective is not merely to understand how commerce operates. It's to understand why it does. Okay. Not just how it does, but why it does. So once the first principles are understood, individual transactions, they just become easier, right? They're easier to analyze because the underlying architecture has already been mastered. You're not guessing, okay? And to understand something is always requires, understanding what it isn't as well. So what is this seminar not? Let's separate knowledge from speculation, okay? I don't want to get into commercial remedies and a lot of different stuff. That's not where I'm going with this, okay? There's tons of people out there that'll, sell you this week's version of a commercial remedy, okay? There is a lot of misinformation. Some approach it looking for those shortcuts. I need to know how to get out from paying my taxes this year. And again, I'm not saying those aren't legitimate concerns, okay? And I'm not saying there's not ways to organize your systems to reduce all those things tremendously, if not completely, okay? So a lot of others assume that every commercial problem has a document or a phrase that solves something, okay? And that's not jurisprudence. That's not law, okay? It's like pseudo-guruism law, okay? And this course, basically, I'm telling you, I reject the magical thinking. Not because I haven't researched it thoroughly. I've been researching this stuff before the computer and the internet were available. It wasn't easy, okay, where you had to actually seek out the information, okay? But there are no universal templates to fix every commercial problem, okay? But there are principles, and if you understand them and you use them right, okay, and you study sound administration, discernment, judgment, having integrity, okay, the goal is not to escape reality or responsibility, okay? The goal is to administer responsibility wisely, okay? It's better not to have the problem in the first place, right, than to you know, and a lot of folks come out and you know, and come to some of my seminars and a lot of others that, you know, they come out to get a solution to a very immediate problem is usually why people start doing their study. Okay. So if principles are the foundation, then the question becomes, how do we actually study those principles? Okay. So we understand, we discern, then we administer. Okay. It's never knowledge just to get knowledge. You can cram as much knowledge in. Okay. That's not the objective. Okay. The information without discernment, okay, it's not going to help you. It's going to confuse you. We get a lot of folks that come to me and go, hey, you know, this one teaches that, and that one teaches this, and this one's teaching that, and you know, they're taking a course, and it's you know, you can't scatter yourself, right? You can't be studying different concepts, get one down, and then build on it. Okay, and that's kind of how I try to teach, right? You know, each principle builds on the principle before. Each lesson builds on the lesson before. Okay, following a deliberate process. Okay, so first we gotta seek understanding. We define our terms precisely. You know, anybody who's studying law, you know, law is very exacting. Okay, we examine history. We identify the first principles. Okay, etymology, right? We go back to the foundation of a thing. Okay, we then exercise discernment. We compare, we distinguish, right? We test assumptions. I mean, anybody who's studying law, I mean, one of the things that you look at first are, what are all the assumptions that you have to overcome, test, use evidence, right, to overcome. And then you have governing principles, and then you administer, okay, by that set of governing principles, your indenture. Administration is when you take that knowledge and you put that into wisdom and put it into action, okay? You do not react emotionally. Usually you act emotionally when you're not prepared. You got a test coming up and, you know, you didn't study, and, you know, the night before you're getting emotional, nervous, fearful. How many people have gone to court for something, even as small as a traffic ticket, and were shaking in their boots, not knowing what's going to happen? But if you don't understand, you know, what's going on, it's very overwhelming when you don't know. So basically, understanding how to deliberately govern your decisions, and you do that through structuring, and that's what the course is about. Okay. All right. All that, and here we go at the beginning. Okay. So one of the greatest mistakes in education is presenting isolated facts without structure Anybody that's been in my courses or is taking my courses, I really do try to build one step at a time. Okay, structured learning. The information's presented. Okay, and knowledge becomes durable when you understand. Okay, that you can build a full concept into a principle. Okay, just by building that foundation, right? So we begin with the nature of commerce itself, okay? Then we're going to study how obligations move, okay? Then debt, then credit, then administration, and then every lesson prepares you for the next, okay? It's not just a collection of topics. I'm trying to build a picture here for you so that you understand the material when we're done. Okay, so the course, it's a complete commercial framework designed to develop your ability to reason through commercial relationships. Okay, then going in and trying to memorize a whole bunch of disconnected rules. Okay, so now we left the foundation, and whoa, I don't know what just happened. Sorry about that. Give me 1 second. All right. Whoops. There we go. All right. So let's begin examining the system itself, okay? As we move through these lessons, I want to encourage you to resist the temptation to just look for immediate application, okay? Understand it first. The application of it will be explained as we go through. Okay, so instead, look at the relationships. How do things interact? Okay, how does each principle connect to every other principle? Okay, because commerce it's not a collection of independent mechanisms. It all literally is a very complex, integrated system of relationships. And the four main things they look at are obligation, documentation, administration, and trust. Is there any? Right? So once you begin seeing those relationships, you never look at commerce the same way again. Okay? So negotiable instruments. So when you look at negotiable instruments, you'll see them every day, and you'll see that as we go through this. Okay, every single civilization had encountered the same problem. Okay, how do two parties exchange value when they can't perform at the same place, at the same time, or with the same certainty? Right? It's not always apples for apples. It's not. Sometimes it's apples for oranges or apples for pears. Right? So commerce answered that problem by creating negotiable instruments. Okay, a negotiable instrument, it's not just a piece of paper, okay, especially in law, and you'll get that, when I teach, it's from that legal bent because that's been my focus for the last 40 years or so. So it is a legally recognized embodiment of an obligation. Okay, it can be transferred from one party to another without destroying the underlying right. Okay, and that is basically these negotiable instruments have changed things. A lot of them used to represent actual things of value, money, things that have inherent value. Okay, we'll get into fiat a little bit in the seminar, not a whole lot. So basically, it allowed value to travel further than the parties themselves could travel. Okay, long before electronic payments, long before central banks and all these modern fiat currencies, because it's not just U.S. currency, it's all of them. They're all fiat. All right. Negotiable instruments were already allowing commerce to move across kingdoms, oceans, and generations. Okay. They're amongst the greatest legal invention of history, of civilization, okay, says some, not necessarily me. But they did transform promises into transferable commercial assets. So the piece of paper, that promise, is a right, and rights are ownership interests. You probably heard me say that a time or two. Okay? So when you understand the nature of negotiability, then we can look at, some of the other forms that these instruments take. Okay? Start looking at notes and drafts and checks and bills. Those are common negotiable instruments, right? A lot of folks mistake and assume that every commercial instrument performs the same type of a function. They don't. Okay, every single one. There are so many differences. They're all contracts. They're just a lot of different types of contracts. But basically, a note, okay, is a promise. It's a promise from you to whoever you're promising. Okay, a draft is an order. Okay, a check is a specialized draft. Right, it's directed to a financial institution, paid to the order of, and whoever the name on the check is can go to that institution and hand that check to them, and they would pay out the face value on the check. A bill of exchange. A lot of people ask about bills of exchange, okay? It's a commercial order, okay? Usually, you get a purchase order is kind of like a bill of exchange, okay? They historically enabled merchants separated by oceans to trade without transporting gold or silver, especially, look at the wrecks under the ocean of all those ships that went down way back when, with gold and silver on them. They were losing the actual value. So these things represent value of some sort, okay? They also determine who bears the obligation, okay? Who carries the risk, how performance is demanded, and just like anything other legal document, the precision of the language produces the precision of the administration. So among all these instruments, this became the modern foundation for credit relationships. Promissory notes. Okay. Promissory notes. Every single dollar in your pocket is a promissory note, a Federal Reserve note. And I'm not going to get deep into this again either. I've got tons of calls that I speak about it, but that's a very, it is a promissory note from the government, from the American people, or from wherever country you're in, to the government, and then to the central or the Treasury, and there's a few players in between. Again, I don't want to get into that. I want to cover the promissory note itself. Okay, so every credit relationship begins with an intellectual act. Okay, it's a thought before it becomes a financial act. Okay, it's something you think about or you don't. A lot of folks' thought process goes, "Wow, that's a really nice car. How much is it? Oh, okay, and run my credit and approve me, get me approved, and I want the car." None of the contract or any of the other documents that were signed get even looked at. Okay, so one party expresses confidence that another is going to perform in the future. Okay, the confidence is memorialized in a promise. A promissory note, okay, is the evidence of that promise. Okay, it's also evidence of a debt. It's a written acknowledgement of an obligation voluntarily undertaken. Okay, equity does not aid a volunteer. That's another talk, but voluntarily undertaken. Okay, notice what actually possesses value. Okay, it's not the paper. Okay, the enforceable promise evidenced by the paper. Okay, there's a difference. The value is the car that you purchased. Okay, the note is the obligation that you have to pay it back. Okay, so it's a real fundamental distinction. Okay, commerce does not trade paper, even though you would think it does. It does. There's a market. Okay, but it doesn't just trade paper for paper. There has to be a value behind it. Okay, what it does trade is legally recognizable rights, which are ownership interests. Okay, and obligations represented on paper or by paper. Okay, the instrument itself is evidence. The obligation is the substance of that evidence. Okay, on both sides, right? It could be the property is the substance as well on the equitable side. The obligation is where a legal responsibility is owed. Okay, so a promise alone does not move money. Okay, so commerce also requires mechanisms for directing payments. Okay, you've probably gotten one of these, probably not in a long time, but at some point in your life, you've probably either paid by a check or gotten paid by a check. Okay, so checks and bank drafts are instructions. They're not currency, right? A dollar bill, or those would be considered currency. Okay, but a check, okay, it's not money. Okay, a check is an instruction. It's an order directing a financial institution to pay funds from one's account to another. Check itself possesses little intrinsic value, has no intrinsic value other than if you were out in the woods cold and needed to start a fire. Okay, it's instructions. So it's the commercial significance arises from the relationship among the drawer, the drawee, and the payee. Okay, so until presentment and honor occur, okay, the underlying obligation may remain unresolved. So let's say I gave you a check for $100 and you lost it, and it never leaves my account. Okay, until it's presented, okay, and honored, okay, the obligation may remain unresolved. In other words, you can't collect it because you don't have the original check. Somebody could find it, but if it's not made out to them, these were how these things were used. Okay, so commercial law, okay, places a lot of importance upon proper presentment, honor and dishonor, notice and timing. Okay, commerce doesn't depend just on the payment. Okay, but orderly procedures that do govern the payment. Okay, and again, I spent a lot of my adult life in commerce and dealing with these things. I am not picking I'm not judging commerce one way or the other right now. I do have, and if you listen to me long enough, you'll know how not only how I deal with it, but also how I feel that it's not a great system. But better to know about it than not know about it and get taken advantage of. So once an instrument exists, commerce faces a whole other question. Okay, how do the rights move from one holder to the next? Okay, and I don't know if you've heard about endorsements before. Okay, but endorsements move possession, okay, of rights. Ownership and possession are not always identical. Neither is possession and enforceability always identical. So endorsement is the legal act by which rights evidenced in a negotiable instrument are transferred from one holder of that instrument to another. Okay, every endorsement extends the commercial life of the instrument. It creates a chain through which rights can be traced, authenticated, and then ultimately enforced. Okay, so this is why the endorsements matter. Okay, they preserve continuity, they preserve accountability, and they preserve certainty. Okay, and without those methods for transferring obligations, negotiating, overseas or even across town, it could collapse. Right? There's no record keeping. There's no way to evidence the ownership of something. Okay, so possession of an of an instrument alone does not answer all legal questions. Okay, Commerce asks also who possesses the actual instrument and under what legal status do they hold the instrument. Okay, you may have heard of the holder in due course or holder as well. There's two different. So when you're looking at jurisprudence or the science or the law behind how things work, okay, commercial confidence or trust in commerce, okay, depends on one principle: confidence. Right? Do I trust that person enough to, give them something today for, repayment next week? So commerce definitely depends on confidence. Okay, if everybody receiving a negotiable instrument had to investigate the entire history of every prior transaction, commerce would grind to a halt. Okay, you can keep it very simple. Okay, but I'm not explaining simple. I'm trying to explain the system, how it is. Okay, so the law distinguishes between a mere holder of an instrument and the holder in due course. Okay, holder possesses the actual instrument. Okay, the holder in due course possesses the instrument under circumstances that the law recognizes that has a greater protection. Okay, it deserves a greater protection under the law because anybody can hold the instrument. Okay, the holder in due course has a right to hold the instrument. So hopefully that distinction is simple enough. I hope you guys get that. If not, write a question down and we'll get to that toward the end here. All right. So the distinction, it wasn't created to benefit banks or merchants. Okay. It was designed to create and preserve negotiability itself. Okay. Encouraging good faith transactions, allowing certain purchasers to acquire an instrument properly, okay, for value and without notice of certain claims or defenses to rely on it, okay, rather than having to litigate every previous dispute, okay. Commerce functions because confidence is protected where the law determines protection is justified. This is a tough conversation for me to have because, again, I looked at this for 40 years of commerce. Well, not quite that long, 25 before I decided to opt out of the public commerce system. But it's just I'm not going to even get into it. Sorry. Back to where we were. So when you have the strongest commercial rights, okay, it depends on one critical event. Okay, the instrument itself has to eventually be presented. Okay, it has to be presented for performance. So presentment and dishonor. Okay, demand, performance, and commercial consequences. Every obligation eventually reaches a point where performance is going to be requested. Okay, a lot of people don't like that. They love the vehicle when they bought it. They love the furniture when they got it. They love the house when they got it. And now this breaks and that breaks and somebody dented it and, but the obligation still exists. Okay. And that when performance is requested, that's known as presentment. Okay. Presentment's not just asking for payment. Okay. It's the formal or legal act that calls the obligation into performance. If the obligation's honored, okay, the commercial relationship usually proceeds to discharge, or, which ends the relationship, discharge. Okay. If it's dishonored, a whole different body of commercial rights begin to come up. Okay. Depending on what was in that contract or a bunch of contracts that you signed when you got the benefit, when they gave you those keys. Okay. That were in those documents that you signed. Okay. So notice, okay, is what commerce is doing. It's creating a certainty. Okay. Performance produces one legal consequence, right? Discharge. Non-performance produces a whole other one. Okay. And commercial law exists not to eliminate disagreements, but it establishes predictable consequences when agreements are fulfilled or broken. And literally, the commercial law, those statutes to protect consumer law and debt collection laws and things like that, okay, exist. They're not perfect, but this is the system that we're, discussing here, okay, whether it's good or it's bad. We're not going to judge it, but at the same time, understanding how it works, okay? So they try to establish predictable consequences when agreements are either fulfilled or broken. So when obligations move and when performance is demanded, the next question is, can those rights continue moving after they're created? So assignments, transfers, and allonges, okay, are the mobility of commercial rights. Okay. They're used to move those rights from one to another, one party to another. Okay. The rights themselves possess the value. Okay. The right, not the paper is the evidence. The right is the value. Okay. Anything possessing value eventually becomes transferable. Okay. An assignment is the legal mechanism by which existing rights move from one party to another. Okay. An allonge serves a much more limited purpose. Okay. It extends the instrument, when additional endorsements can no longer be placed on the original document. Okay. So, it's kind of like add an extra include an extra document if you have more complaints or more things. Okay. And allonge adds to, the document and attaches to the document as an extension for further endorsements. Okay. And basically the instrument, when they both basically exist for the same reason, both of those doctrines. All right. They preserve continuity, and commerce depends upon the ability to trace how rights were created. Okay. How they were transferred and how and who. Okay. How and who lawfully possesses them today. Okay. The chain of title is not administrative trivia. Okay. And if you're administrating your affairs and trust, hopefully, then chain of title, is very, very important. Okay. To build the foundation of your evidence of rights. That's what we're talking about. Transferring of rights. Okay. So commercial relationships are not always performed exactly as agreed. Performance may not be as exactly as agreed, right? So there may be lots of reasons that, you may want to, change the contracts, right? So relationships are, you have snafus that have to be worked through. All right. Default and acceleration. Okay. when time changes the obligation, okay? I signed up for this house, but I agreed that I'd pay for it for the next 30 years, but I lost my job 3 years in, and now, how am I going to, we always find, people find themselves in situations like that all the time, right? So every commercial obligation contains more than just an amount. It contains time, performance on the agreed dates as part of the agreement itself. Default occurs when performance fails according to the terms the parties agreed to, right? Acceleration is the contractual consequence by which future installments may become presently due immediately when specified conditions occur. Foreclosure, very good example of that. Okay, someone defaults, and foreclosure is the acceleration, okay, that occurs. Notice that the acceleration is not a punishment, okay? It is a risk allocation mechanism negotiated within the agreement itself. So I'm going to say this, looking at it as if I am the bank, okay, the lender, because I have worked in commercial finance in that industry for many, many years. And when you're trying to get somebody financed, okay, this is what the banks look at. This is what the person or company that's lending you money is looking at, okay? And they want little things in their contract that protects their rights or their investment in whatever it is they're investing. And again, we're not going to get into fiat and who's lending this, that, or the other. Plenty of gurus out there talking about it. I just want to keep to what this system is, how it works, and how you can navigate it without getting run over and taken by it. Okay? So, a wise administrator, a good trustee, studies the allocations before they sign it. Okay? Not after difficulties appear. If you're going to be a good steward, you're not going to run in there because you want the shiny little car because it looks so nice and you'll look so great going down the road. Okay? You have to really analyze what it is and what its purpose is going to serve within your estate, right? Because once the obligation exists, the final question remains, what secures the promise if performance never occurs? Hey, you got the car, it was nice and shiny, you lost your job, and next week you see the repo guy driving it down the road with your, with your shiny little dice in the mirror. I mean, it's gone. Okay. So that brings us to security interests and collateral as to why they require these things. Okay. And the most important distinctions in commercial law is the distinction between an obligation and the property that secures it. And again, I told you, I dissect and reverse engineer when I study law. Okay. What does this do and how does it affect that? Okay. But ultimately, the promise to perform is one relationship. The collateral is another relationship or interface, if you're a student and you understand what I mean by interface. Okay. A security interest does not create the obligation. Okay. It provides an additional source of recovery if the obligation is not performed. And usually when you buy something like furniture or a car or a house, anything on credit, unless it's unsecured, it's collateralized by the thing you bought or that you were, you didn't really buy it, right? You became a debtor to buy it. Okay. You have an obligation still. So, basically, understanding that distinction explains a whole bunch about modern secured commerce, okay? Rights in the obligation, rights in the collateral, rights of priority amongst competing claims, all right? These are all related doctrines, okay? But they're not identical, okay? And if you're a faithful trustee or if you're a good administrator, okay, you learn to distinguish them carefully, okay, because precision, okay, in especially legal terms, if you find yourself in problems, okay, having that precision, is good judgment. It's good commercial judgment, okay. So we examine principal instruments through where commerce records, transfers, and secures obligations. Okay, so the next question isn't now how does commerce work? Okay, so it's how does a trustee think within that system? Okay, so a trustee or a steward is not a reactor. Okay, is not emotional. You gotta be, if you're prepared for the test, you're not going to be afraid. You're not going to get emotional. You're not going to just react. You can take the time to think it through because you already thought it through prior before you go and buy that shiny car. Is it worth it? Okay. How's it going to pay for itself? Okay. So everything we studied so far has just been about understanding how commerce functions. I want to shift it now to how you think as an administrator. How do you work your way through commerce? Okay. Most people spend their lives reacting. They react to bills, lawsuits, the banks, the government. The trustee does not react. Okay. We administrate. We administer the trust. Okay. We just do our job. Right? Isn't that, how many of you heard that term before? I'm just doing my job. Okay. You study before you sign. You plan before you act. You document before there's conflict. And you understand that every commercial relationship creates both opportunity and responsibility. Even if none of this system here that we know as commerce existed and you were just trading with your neighbor, okay, and you gave your neighbor a bushel of apples and he said, you know what, in the spring when you're, or in the fall when you're, when your vegetables come, you can get me back, right? And the farmer, goes and gives him back, the worst of his harvest instead of what he agreed to. They're not going to be doing business very long, simple. So the consumer asks, what can I buy? Give me the benefits, right? The debtor asks, how much am I going to owe? What's my obligation? Right? What's my monthly payment? Can I afford the monthly payment? And a trustee, we ask a totally different question, okay? What's been entrusted to my administration and how do I govern it faithfully and with the fiduciary duty to both the grantor and the beneficiary, okay? That's what administration is. You're doing something that is not necessarily for your personal benefit, although a lot of the times it is. Okay, so before we connect everything else that we've learned so far, okay, I want to notice what we actually have gone through. Okay, we haven't memorized definitions; those are in the course. Okay, but I'm trying to construct a framework. Okay, debt is not simply just an obligation. Credit is confidence. Okay, negotiable instruments move obligations. Documentation preserves rights. Presentment demands performance. Security interests reduce risk. Administration governs the entire process. Okay, and that these aren't isolated topics. They're interconnected parts of one commercial system. Okay, and in that commercial system, you have public and private commerce. Okay, so once you begin seeing the relationships instead of the individual pieces, all of this should start to really make sense to you. Okay, and this is how trustees think. They don't just manage documents. It's managing relationships, interfaces with everything. Okay, so let's see what the difference looks like in practice. Okay, we do a lot of case studies in the courses. Okay, And I find that it helps to get a better picture to cement the principles in your mind. Okay. So the difference isn't intelligence. Like I said earlier, I've met doctors and even lawyers and, people that make big money and are supposed to know all kinds of stuff. And they're just not financially or commercially educated. So it's not intelligence. Some very, very intelligent people are broke. Okay. So imagine two people receive exactly the same collection notice, right? Same creditor, same paperwork, same amount, right? One immediately becomes emotional. They argue, they panic, right? They make decisions from fear. And the other one just begins asking questions. What created the obligation? Is the documentation complete? Who currently owns the claim? Has every required commercial step occurred? What remedies exist? Okay. The difference isn't intelligence. The difference is how you administrate. It's administration. Okay. One reacts to events. The other administers facts. Commerce, okay, will always reward the second approach. Okay. And when you understand how the system works, okay, you can avoid a lot of the pitfalls. Okay. So basically, learning to think commercially, I spent most of my adult life living behind a corporate veil, operating in this world's commercial system at arm's length. Okay. That and trusts. And we get into a lot of that other stuff. But it's commerce, learning to think commercially, okay? When you're looking at this system, okay? Challenge your own assumptions. How many commercial relationships have you entered simply because everybody else is doing it, right? It's like the Jeep fanatics. I've got a couple of family members that are all into the Jeeps and they're rubber duckies. I don't even understand it. So, but a lot of that's because other people do it, right? Trends and things, we see it all the time. Oh, I've got to have it, right? And how many documents have you signed without understanding the obligations they created, right? How many financial decisions do you base on emotion instead of, even marginal administration, right? And again, this isn't about blaming ourselves, about, recognize what things that we were ignorant of in commerce that ended up being real expensive, right? You got an expensive education from, okay? But it does create options. That's what education does. It does create options. It also says, wow, I won't let that happen again, right? So when you recognize that ignorance is expensive, okay, you start to see the value in understanding the system and how it is, how it runs, so it doesn't run over you. You can utilize it as a tool, right, and master it rather than it being your master, the borrower or a slave to the lender. All right. So now that we've built a bit of an intellectual foundation, let's get into some of the mechanics. Okay. Everything we covered to this point is basic foundational stuff. Okay. And I've got a lot more to go here, guys. But again, I wanted this to have some substance. I am doing this a little different than I have in the past. So bear with me. I hope, even if you haven't learned anything to this point, we'll get to more of the meat of the seminar as we build upon, one principle at a time here. All right. So now you understand the vocabulary, the relationships, the legal architecture that supports commerce. Now we can begin to study how these principles work together. Okay. So we follow obligations as they move through the commercial system. We'll examine how instruments create rights, how documentation preserves rights, and how administration protects them. Okay. Most people see commerce as 1,000 disconnected transactions. Okay. I want you to really start seeing it as one integrated system. Okay. And the principles that are governing it. Okay. Because the principles have been around a lot longer than these countries and nations and people and this current civilization that use them. Okay. They've been around a long time. Okay. So you stop being controlled by the system once you understand it and you see it fully. Okay. And then you can administer your place inside of it, in it, but not. We talked about we're going to visit it. So that's question. Should arguments so and you hold better the contact and language just are that some word about actual show, but so happy localized and economic growth for big nations and even towns would be totally restricted. Okay, the negotiability of these paper tools, okay, solve the problem. So it allows obligations to operate under defined legal rules to become transferable assets. Okay, the rights are the assets. The tool is what we use to move them, right? We spoke about that earlier. So it allowed obligations under defined legal rules to become transferable assets. Okay. Modern finance, even today's fiat-based financial system, it depends upon negotiable instruments moving obligations between party A and party B and party C and party Z. Okay. Technology has changed for sure. The principles, the legal principles have not changed since time immemorial. Okay. Commerce still depends on confidence, documentation, transferability. Okay. So why did commerce need negotiable instruments in the first place? Okay. It solved problems. Okay. It solved problems that allowed you to expand the ability for voluntary exchange. Okay. Every commercial instrument exists because it solved a practical problem. Contracts themselves exist the same reason. Okay. Distance creates uncertainty. Time creates risk. Trust requires documentation. You hear that from me all the time. You have to have your evidence, right? And if you thought you were coming to learn how to do credit repair and all these different things, set up business credit, separate you from the entity, blah, blah, blah. Yes, it's all part of it for sure, okay? But it all is interlocking, okay? So when you start to study commercial law, right? Don't begin by asking, what does this document do? Okay. When you start analyzing the contracts, especially negotiable instruments and promissory notes and loan documents, okay, don't begin by asking, what does the document do? Okay. What problem was the document originally created to solve? Okay. Setting up companies over the years, you have a contract. Your company has a contract that starts out, it may be a page or two, that turns into a 30-page behemoth because every single page, every little term in that contract was a problem that they had prior that had to be addressed. So they kept, morphing their original contract over time because you couldn't foresee all the different problems that you could possibly have in the future. Okay. So one of the oldest solutions was the promissory note, or the IOU, right? A promise that can be relied on. Can it be? You may ask with, fiat currencies and those notes that get passed between people every day, whether the promise can be relied on. That's a whole other topic. But all of this commerce is built upon promises. You look at it all the time with these countries' currencies just fall apart, right? It's throwing them all over the streets, burning it, right? It happens all the time. But because it was built on promises, and some are spoken, some are written, right? But promises create a much greater certainty than a memory, okay, a written promise. Well, you owe me this. Well, no, remember I told you that I would do this and that would take care of it. It's very unreliable. It causes so many problems. And years ago, I even write contracts between my family members because, it just keeps everybody on track. It's not even, to hold them legally responsible, right? But so everybody knows what everybody's responsibilities and duties are and what the benefits are, right? So a promissory note transform intent. I intend to pay you back into evidence, okay? A promissory note transforms intent into evidence, okay? It records who promised, what was promised, when is it due, and under what conditions, okay? And the value, okay, is not the ink. It's not the paper, okay? It's the obligation or that the paper evidences or memorializes, okay? And as a trustee, you learn to distinguish substance from evidence, okay? And one records the other, okay? Confusing the two of them creates a bunch of misunderstandings all the time, okay? A promise creates an obligation. A payment order moves value. Okay, so we're going to come back through some of the different negotiable instruments here, checks and bank drafts. Okay, and these are payments through trusted, intermediaries. Right. As commerce expanded, parties needed safer ways to move value rather than carrying the actual value thing, right? You get mugged on the side of the road, they may get a check, but they're, again, these negotiable instruments you have to prove who you are. And so nowadays, even if they don't have a check, you gotta put your fingerprints, and they want biomaterials and whatever else. Okay. But checks and bank drafts became trusted instructions directing financial institutions to transfer funds from one party to another, okay? The bank isn't creating that obligation. They just facilitate performance out of an account that you have somewhere in their records, okay? Within within that relationship, okay? The commercial relationship existed already. The check simply provides an orderly mechanism for settlement of a debt. Right? Something owed for something bought. Okay. And that's why timing matters, presentment matters, honor matters, documentation matters. Commercial law isn't obsessed with paperwork. It's obsessed with evidence, certainty. Okay. International trade was a whole other thing, a lot more sophisticated, a lot harder to do, especially before there was SWIFT, electronic banking. So merchants conducted international trade using bills of exchange. The instruments allowed obligations to travel, reducing the need to transport gold, silver, and other species across, pirate-infested waters and dangerous oceans and other trade routes. Okay. In many respects, they became the financial infrastructure of all of international commerce was built on bills of exchange. Okay. Even now, a lot of these digital currencies, instead of paper documents, right? But the legal concept and the principles underneath are identical. Okay. So the technology may change. The principles always stay the same. This is why principles are a lot more useful and a lot easier to learn, okay, than trying to keep up with, oh, this week they changed the law on this, and now you got to file this instead of that, and this has to go with this now. And, those things change all the time. Technologies change every week, it seems. Commercial principles, the principles survive and have survived. Basic commercial principles have been around since there were two people to trade. Okay. So now that we've seen the obligations move through commerce, okay, so let's examine what those instruments' legal power is as they pass from one hand to the next. Okay. So we're going to revisit the endorsements. Okay. And it's the signature that moves rights. Okay. Not every signature moves rights. This signature, when you're endorsing something with a signature, okay, you are literally moving rights. Okay. It changes your legal position and the legal position of the instrument. Okay. That's what the power of an endorsement is. Most people think a signature just identifies who signed. Okay. But in commerce, a signature transfers rights or can transfer rights, creates warranties, assumes liabilities, or authorizes the next transaction. Every endorsement becomes another link in the chain of title. That chain tells a story of where the instrument has been, who possessed it, and who has the authority to enforce it now. Okay, and this is why trustees never really sign anything casually. Okay, every signature should answer at least three questions. Who am I acting as, right? What capacity? What authority do I possess to act? And what are the legal consequences or obligations that follow this signature? Okay, before you do it, think about just these three things. And you may not buy that shiny red car or whatever. You maybe you figure out something else. Makes more sense. Okay. Administration begins long before your signature ever touches a piece of paper. Okay. Because once rights start moving, then you got other questions. Who's holding the interest, right? Who's holding the instrument? Who's holding the rights? So status determines your protection. Commerce doesn't simply ask who possesses the paper, right? They ask under what legal status do they possess it? Are they acting as agent for a business? Are they acting on their own behalf? Are they acting on behalf of another? Okay. There's a very big distinction. Okay. A holder has possession. We spoke about it earlier. A holder in due course possesses additional legal protections because the law recognizes that commerce depends on good faith purchasers being able to rely on the negotiable instrument. Okay, a holder in due course has a much stronger underlying right. Okay, the doctrine, it wasn't created to favor one party over another. It's just it was created to encourage confidence in commerce itself, okay? Because the second you lose trust in something, your currency goes out the window and trade stops, right? Negotiability dies. And without negotiability, commerce slows down, right? So, I tell people all the time, don't memorize legal terms, don't find this code and that code, and you got to remember this code like you're memorizing scripture. No. Understand the policy and understand the principle behind the policy, okay? And once you understand why a doctrine exists, you'll remember more about how it operates, okay? So every negotiable instrument reaches the same moment where somebody is demanding payment, right? Performance on that note, on that instrument. And that's where theory meets reality. Okay. Commerce eventually asks a very, very simple question. Will the obligation be performed? And the presentment answers, that's what the presentment answers. All right. Presentment's not merely requesting a payment. It's the formal opportunity to perform according to the agreement. That's presentment. You're going to do what you promised. And that is presentment. Okay. The formal opportunity to perform according to the agreement. Honor ends the transaction and discharge. Dishonor, a whole bunch of other stuff comes up. Commercial rights and remedies. If you dishonor what you owe, they're going to come and repo your car, foreclose on your house, garnish your paycheck. These are all things that people worry about, okay, happening. And it's not something to really worry about. You can have contingency upon contingency built into your systems to protect yourself from those things, but dealing with them as well. If you know how to deal with them ahead of time, is a whole lot better than worrying and acting emotionally because you don't know what to do. Having that knowledge, makes you stand a little taller and not be afraid when an adversarial situation comes calling, right? So think about what the law is accomplishing. What commerce is trying to create is certainty, right? Everybody knows what happens if performance occurs. Everybody knows what happens if it doesn't. A good commercial system doesn't eliminate conflict, okay? But they do try to eliminate uncertainty. Okay, and from a bank standpoint, that's what they're doing when they're running your credit scores and checking out your history, your commercial history, right? So, at that point, you'll see a bunch of recurring themes, over and over through here. Obligations don't rarely remain within one party, okay, throughout the life of the obligation. Okay. The bank may sell your notes, right? They assign it to a collection agency or transfer it to another servicer, right? You'll see these are things that may or may not have happened in your life and you've had experience of. Okay. But these are following the chain of title. Okay. Assignments, transfers, and allonges. So when you're looking at and trying to analyze debts and notes, and you're looking at these instruments, trying to figure out what they do, their evidences, okay, the chain of title, how they went from here. How did this person get it from the last person? How did you get it? Look at the title of a car title. That's an older car that's been bought and sold multiple times, right? There's a chain of title. It went from this owner to that owner to this owner to that owner. And that chain of title, it'll stand in court as evidence, okay? It shows how the rights move, how every time it was assigned to someone new. Shows me every endorsement. The proper party had the right to transfer it, okay? And it shows me every other transfer that happened before I got it, okay? So commerce depends on continuity. If rights are transferred, they have to be traceable, okay? If ownership changes, documents should demonstrate how, all right? Every missing link raises questions. Every undocumented transfer creates fear, uncertainty, right? And this is why documentation is not just paperwork, okay? It preserves commercial memory. Okay, and I say that because we're talking about commerce, but we talk about documentation all the time in preserving your trust estate and protecting your trust estate. Evidence is what wins cases. Okay, So it allows today's administrator to understand the decisions made years before. So if you were, in a legacy trust where, this is how it's been running for 2 generations, and by the time it gets to you, they worked out a lot of those bugs. They fixed their contracts, and they left you a roadmap on how to operate it at that level of, precision and practicality. They worked out all the bugs for years. Okay? So every commercial relationship faces the same possibility. Okay? Someone doesn't perform, then you have default and acceleration. Okay? Risk was planned before the problem. Okay? And the greatest misconceptions about default is, people believe that default begins when somebody misses a payment. Okay? In reality, default begins the day the agreement is written. I'm going to say it again. Default begins the day the agreement was written. Why? Because the agreement already defines what default means. Okay? You agreed to it. It means this, that we will foreclose, or we will repossess, or we will do this. Okay? That's one of their remedies. So you signed up for it right there at the beginning. It shouldn't be a surprise. Okay? It allocates the consequences. It identifies the available remedies to the parties if one of the other parties breaches, right? Commercial contracts anticipate failure before failure occurs. This is why contracts that were started when a company started have grown and morphed into much more protective documents over the years. So, and again, commercial contracts anticipate failure before failure occurs. And it's not about pessimism. That's administration. And if you're a good administrator, you would be doing the same thing if it was you lending. Okay? You'd want to, if you were lending estate money, your beneficiary's inheritance, right? And something, you better have done your homework, right? Administrate, ask the right questions. Okay? A good administrator doesn't hope that problems never arise because, problems always arise. Okay? They do prepare for them when the relationships are healthy. Okay? It's really a big difference between consumers and a trustee. Okay? Consumers react to problems. Trustees administer risk before the problem even appears. It's built into their system. Okay? Preparing for default, it leads to the final question. What actually secures the obligation if performance never comes? Some people have felt like they've been in that chained up front door. It's not a good feeling, separating the obligation from the security. Again, one of the most important distinctions a commercial administrator learns is that obligation and the collateral are not the same thing. The obligation, the IOU, the promissory note is the promise. The collateral is security supporting that promise in case, of non-performance, right? Two distinct legal relationships. People lump them together, especially a lot in the internet guru forums where, the IOU, the promissory note, without the security agreement that is attached to a security, right? If they aren't attached to each other, there could be some legal issues, but they are two separate legal relationships. Okay? A security interest does not create the debt. Okay? It creates priority in identified property if the obligation isn't performed. Okay? Secured transactions are one of the greatest developments in commercial law, right? They reduce uncertainty. I can take out a secured card, go into any bank, give them $5,000 and gold, silver, or currency, and they will give you your money at interest and provide you a fancy little car. Easiest credit to get, right? Secured debt. And it can be used to leverage, okay? Anyway, I'm not getting into that. That's another seminar. Anyway, every trustee really does need to learn to ask, what secures the obligation? Has the interest been properly created? Has it been perfected? Has the lien been perfected? Who has priority to collect it? Okay. So the questions reveal the commercial reality long before litigation ever becomes an issue. Okay. So when we step back and watch the entire commercial process unfolding from the beginning to end, okay, and everything now that we've been talking about begins to connect. Okay. Commerce isn't random. It follows a very consistent sequence. Okay. First, somebody creates an obligation. Then the obligation is memorialized in an instrument, a negotiable instrument. Rights can be transferred through endorsements or assignments. Presentment demands performance. Honor satisfies the obligation. Dishonor creates remedies. If you have a right, a remedy is created, and it's usually spelled out very specifically in the contract. And if collateral exists, secured rights begin to operate, right? Once appeared to be a whole bunch of different unrelated legal concepts, okay, it is literally just one continuous commercial life cycle of an obligation. Okay, so once you can see how it flows, individual transactions become a whole lot easier to understand the whole picture, front to back, okay? So let's apply that to a very familiar commercial transaction. Okay. So imagine purchasing a piece of equipment for your business. Okay. Most people believe they're simply just buying a piece of equipment. Okay. But a commercial administrator or a trustee, they look into much more than that. Okay. There's a purchase agreement. There's a promissory note. There may be a security agreement, financing statements, assignments, payment instructions, insurance requirements, default provisions. Okay, and every one of these documents governs a different relationship. So the equipment is only the visible part of the transaction, like the shiny red car. Okay, and commerce is actually occurring through the documentation. Okay, and when you learn about this and you become a little bit more experienced studying these documents, okay, then the property itself. Oh, I love how that, the heated seats work and this and that. It's all great. But, one cold morning you wake up and you forgot a term of that contract and the repo guy's rolling down the street with your heated seats. Okay. So once you begin seeing transactions this way, many of the repeated beliefs begin to fall apart. Okay? Common misunderstandings. When you separate commercial myths from commercial reality, this is why, I used to years ago teach a commercial remedy, and, from years and years of dealing with commercial remedies. Commercial remedies are legal remedies. Okay. So let's get rid of the myths and look at the reality of it. Okay. One of the goals of higher education is learning to question assumptions, right? People tell me, well, the law says all the time, okay, but that's assumptions. They assume that the law says that. They don't know. Okay. The law itself uses presumptions and assumptions all the time. So that would go to say that all these commercial contracts are full of assumptions. Okay. How about I signed it, so I owe, or the bank owns the debt on my house or my car. Possession proves ownership. No. Payment ends every obligation. And they may be true. They may be partially true. And then they could be absolutely, completely wrong, depending on the facts and the the actual evidence. Okay. So trustees don't operate from slogans. They look, they investigate, they document, they verify, they document, right? Evidence. It's always about evidence. Okay. So if you are dealing with debt related issues or trying to build credit for your business or anything like that, okay, these are things that you can use, tools that you can use, and principles that you can follow to help you navigate through these issues. Okay, so commerce itself will reward precision. They do reward. If you've got an 800 credit score, that bank, and then you've got multiple relationships with banks and lots of liquid cash and assets, that bank will lend you whatever you want. Okay. But you can have an 800 credit score and not have the assets or the history of managing those assets. And you won't get the same terms if you're able to get them at all as the same person with the 800 score, same score as you. Okay. Different histories. And let's move on. All right. So from understanding commerce to administrating it. Okay. So we covered a bunch of material already. I get it. But understand what we've actually accomplished. Okay. Is we're not simply learning about commercial terminology. Okay. It's a different way of thinking. Okay. You begin to see obligations instead of invoices, documentation instead of paperwork, relationships instead of transactions, administration instead of reacting. Okay, and that's the objective. That's my hope. Okay, is that from this point forward, we build upon that foundation and continue building, our state here. So we move from understanding commercial mechanics to understanding debt, credit, banking, and administration at a deeper level. All right. So as we move forward, don't lose sight of the principles. Okay, knowledge gives you awareness. Discernment allows you to exercise the knowledge that you have, okay? And faithful administration will produce freedom and separation if you understand how to use the tools, okay? And that's the difference between participating and being a consumer in commerce, okay, and governing your affairs with intentional stewardship. So, all right, interest. The price of time and risk. When people think about interest, they always have a lot of misconceptions, okay? Believing that it's money creating more money. Anybody that's studied fractional reserve banking or banking at all knows that's not true. Or even insurance for that matter, or anything that has to do with these financial, economic the terminology here. Okay. Interest is not creating more money. Okay. The money that's created in fractional reserve banking, okay, is the money that goes out. Say $100 is created. The interest is not created. So it's, I don't want to get into that. I'm going to go back over here. All right. So commerce didn't historically view it that way. All right. Interest is the negotiated price one party agrees to pay for the other party's for the temporary use of another party's capital. Okay. And they figure that out by their assessment of time, risk, inflation, right? Money's not worth tomorrow what it is today, opportunity cost, and the probability of non-performance. Okay. So that's what the bank's looking at. Interest is. Okay. And that's what the interest is what their price is to consider all of those things together. Okay. And that's what the price assigned to the uncertainty is, the interest. Okay. So throughout history, societies debated what interest is reasonable and when does it become oppressive. Scripture addresses usury all the time. There are multiple scriptures that address usury. Civil governments establish statutory limits. Markets establish competitive rates. And regardless of your position, the principle itself always remains constant. Before you borrow, you should really understand exactly what you are agreeing to purchase. A wise trustee doesn't focus only on the principal, all right? He calculates the total cost of acquiring capital or an asset over time, the total costs, okay? Interest alone doesn't really tell the whole story. So we get to annual percentage rates, okay, APR. And this is where you start to see where the contract, what that contract really costs. APR exists because interest alone can be very, very misleading. There's a few different types of interest and how interest is calculated. Okay, two loans can advertise the same interest rate and have totally different costs associated with it once fees and points and prepaid finance charges and other expenses are included. Okay, especially when you're financing. Okay, if you're financing a car and those same two people with the 800 credit score walk into the car dealership, one's probably going to walk out with a very low interest rate and favorable terms, and the other's probably going to get gassed, 18 to 17, 18, 20% or more, because they don't have the trustworthy history and the available liquidity so that they can lend without having to worry about the risks of it getting it back. Okay. So it's not perfect, okay, but it does give you a far more accurate basis for a comparison, okay? Trustees look and compare transactions. They don't compare the advertisement. They actually look at the contract, the costs of that contract, okay? Numbers contained in contracts determine commercial reality, and it does determine what obligations it's going to hold you through in the future, right? When you're buying on credit, you're literally borrowing away your future. So it's got to be used very, very wisely. Anyway, once the costs are understood, you examine how repayment actually occurs. Okay, then we'll move to amortization. Okay, so early payments build a little bit of equity, right? And why does that happen? If you're paying your mortgage payments and it's the same the payment's the same every month, okay, but only a little bit of the balance is going down, is because usually in the beginning of your mortgage or your payments, whether it's for a car or some other type of note that you're paying, okay, they take their interests up front because that's not created, okay, at the time of the loan. It's created, at the time of the payback. Okay, so you're paying interest in a high amount up front. The principal and the interest eventually will be 50-50, and that, it'll switch, it'll flip, that table will flip the closer you get to finishing paying off that loan. Okay, during the early years, most of the payments each month is applied to interest before principal. Okay, it isn't necessarily fraud. Okay, it's mathematics, and it's smart on their behalf, because if you default, at least you didn't default on the debt that you owe, the interest that wasn't part of the loan. Right? I've been paying this house off for 5 years, and I still owe, a majority of the balance. Well, because you've been paying for those whole 5 years, you've been paying interest. Okay. So the schedule was established before your first payment was ever made, and administration begins before you ever execute the document, the trust, the contract or the note. Okay. Trustee studies the amortization schedule before signing, not years after it's passed. Okay. Because understanding the cost of borrowing okay, can save you a lot over time and save your estate as well. Okay, so when compensation becomes oppression, that's usury. Okay, well, we didn't understand what it meant in the last slide. Every civilization eventually legitimate compensation become exploitation. Okay, and that gave rise to the doctrine of usury. Okay, it's a legal doctrine. While different societies have answered it differently, the underlying concerns are always the same. Okay, commerce supposed to facilitate productive exchange, not perpetual bondage. Right, the borrower is slave to the lender. Okay, Scripture always warns against exploiting another person's necessity for personal gain. Okay, and people think that commerce is all about win at all costs. It's all profit motivated at all costs. I don't care how big a business you are. If that's your slogan and people lose trust in you, you'll go bankrupt real fast. Okay. Civil jurisdictions they have statutory ceilings intended to restrain excessive interest under specified circumstances. And over the years, when you're looking at 18 and 20 and 25 and 30% interest on loans, it's a whole lot more common these days. Because, a lot of it's because of the risks have increased, right? The job markets and the economy are waving. So a lot of it's from that, but a lot of it's predatory. Most of it's predatory. Anyway, moving on. So when approached from moral principles, economics, or even jurisprudence, the law, usury reminds us that commerce carries some ethical responsibilities as well. In the private, in the Kingdom of Heaven Trust Management System, this is a big deal, okay? Because you're literally only as good as your word, okay? So we seek agreements that are sustainable, transparent, entered into with full disclosure and knowingly, all right? Not arrangements that depend on one person winning at the other person's desperation and loss. Okay, and unfortunately, commercial relationship is not always structured that way, and commerce is, it is admiralty, right? The law of the sea. So it's wavy and it's unknowing at times and can be a brutal taskmaster if you are indebted to that system. So when you're indebted, what are some debt traps that you might want to look into, right? So when administration is replaced by consumption, okay, debt's not, debt itself, it's not always the problem. Misadministration usually is the problem, okay? And most debt traps are not created by one catastrophic decision, okay? But 100 small decisions made without understanding and the compounding consequences as well as the compounding interest, right? So when, they'll say, the new student, 18, just got out of high school and now they're getting all these credit card offers, right? And you only need to make minimum payments and you can have revolving balances and repeat financings and high cost unsecured credit. And, they start, living a higher lifestyle on credit cards, which is a fiction in itself, inflating their lifestyle, spending emotionally, right? Not utilizing credit in a way that it's a tool that it makes them money, okay, or increase, right? But in a way that entraps them and enslaves them to more time at the grindstone, okay, in debt, slave to that debt, okay. And individually they all appear manageable, and collectively they produce, long-term financial slavery, servitude, okay. So a trustee, you approach that debt differently, okay. Every obligation has to have a purpose, okay. Every payment should move toward that purpose as an objective, okay. Preferably, it should pay for itself and then some, okay. Then it's a tool, okay. Every commercial relationship should strengthen stewardship rather than diminish it, right? So administration, not income, okay, is the dividing line between usually when, people will be prosperous or perpetually indebted or broke, okay? It's the difference in administration, having systems, knowing what to do ahead of time. When a problem arises, it's not a surprise, okay? And the remedy, you already understand, and what needs to be done. You understand the contract that you entered into, and you only entered into it when you fully understood it. Okay, so when obligations become difficult to perform, a wise administrator doesn't panic, right? They negotiate. So administration before litigation, okay, one of the biggest mistakes most people make is believing that every commercial disagreement has to end in a court battle. It definitely doesn't, okay? Litigation is often evidence that administration failed way before that, okay? Professional trustees understand that settlement is not surrender, okay? Settlement is mitigating and administrating loss, okay? Commerce exists to resolve obligations, not create perpetual conflict. And that may not be the way it looks like, from the world's point of view or from the bank's point of view, okay? But as a trustee or somebody administrating their own affairs, absolutely. Absolutely. Okay? So before negotiating, understand the documentation. Okay? Before making an offer, understand the risks facing both parties. Before accepting any terms, understand the long-term consequences. All right? The strongest negotiator is rarely the loudest person in the room. All right? It's the person who understands the commercial position of all parties involved. Okay? Never negotiate out of fear. Not just fear, guys. Don't get all, I fell in love with this car or this thing and I gotta have it now at all costs. Okay? Don't negotiate emotionally. Don't negotiate from anger. Don't, negotiate from knowledge. And knowledge changes your leverage. Okay? Administration and going through some of these questions that we've been talking about, asking yourself ahead of time, okay, creates options, lots of options, okay? So before you negotiate anything, you answer this simple question. Has the claim actually been proven? Okay? When somebody comes and brings a claim, validation, debt validation, okay? Commerce requires evidence. And one principle runs throughout both the law and commerce, okay? Assertions are not evidence, okay? Commerce functions through proof. I lost the receipt. Well, how are you going to prove that? Okay, if somebody claims a right, show me the instrument, show me any assignments, show me the accounting, and show me the authority that you hold. Are you the holder or are you the holder in due course? Right? Trustees don't reject claims just because they don't like them. Okay. And they don't accept claims just because somebody, makes one. Okay. You administer based on evidence, because that's all that is the facts. That's all you can prove. Okay. So throughout my years developing this Kingdom of Heaven trust management system, documentation has zero emotions. Okay. It either establishes the claim or it doesn't. Okay. Administration begins where assumptions and presumptions end. Okay. But once a claim is established, okay, the next question simply follows is that what are the rights and limitations of those attempting to collect? What are the rights? And what are the limitations of those attempting to collect? So debtors have rights, creditors have rights, and rights exist on both sides of commerce. Okay. Commercial rights are never one-sided. The contracts that you sign definitely could be one-sided, especially if you do not, if you do not negotiate ahead of time, right? But creditors possess rights, debtors possess rights, trustees possess duties, collectors possess limitations. Okay, collectors have lots of limitations. Collection agencies. It's an interesting business model. I've worked with and helped get funding for quite a few of them, actually, over the years. Okay. And there are limitations. There are rules and laws that they have to operate under. Fair Debt Credit Protection Act, right, in the U.S. here, is one of those. Okay. Healthy commerce depends upon everybody remaining inside the rules. And there's one of the snafus right there. Healthy commerce depends on everyone remaining inside the rules. Unfortunately, not everybody does. Okay, on both sides. So, again, understanding that and not being ignorant to that will help you in making your decisions. So every jurisdiction establishes procedures governing collection activities. Why? And I say every jurisdiction. Jurisdiction is authority, okay? And jurisdiction is not just, you're in my county, so I have the authority. We get into jurisdiction a lot in some of the other courses and even the free seminars that are out there. But I'm not going to get into that so much tonight. But because commerce requires confidence, confidence disappears when coercion replaces administration. So understanding your rights doesn't make you anti-creditor, okay? It makes you a competent administrator, all right? And likewise, understanding the legitimate rights of creditors, right? You did sign for the credit. You asked for it, you volunteered, you entered into agreement. You may have just wanted the shiny bauble with the wheels or whatever, but you volunteered and you agreed, okay, by endorsing your signature and transferring rights. So good administration respects lawful rights where they exist, okay? And I'll say that again and very simply. Good administration respects lawful rights wherever they exist. I'm not saying they always exist. Okay. But where they do, if you're a good administrator, you're there to protect the relationship. Right. So eventually everybody discovers something else. All right. Documents alone don't solve problems. Okay. Good administration, and skills in that administration will solve a lot of those conflicts. So what is a trustee standard? Okay. Commerce rewards administrators, not spectators, not victims, administrators. Okay. Professional trustee develops habits that most people absolutely never intentionally cultivate. Right? They document conversations. They think almost like an investigator, right? Confirm agreements in writing, maintains organized records, reviews obligations regularly, anticipates problems before they become emergent, developing the system. All right. It is one of the defining principles of everything that is a part of this system. Systems outperform personalities. Administration outperforms emotion. Documentation outperforms your memory. Stewardship outperforms emotional reactions. And the goal isn't becoming to become a better arguer, right? Well, it isn't to become argumentative, right? And the goal is to become exceptionally competent in managing your affairs, in dealing with third-party interfaces wherever they are, okay? So what is debt, okay? It's a tool, and it could be a tool, and it could be a tool that you use to create your own slavery, okay? So debt isn't inherently good and it isn't inherently evil, okay? It is a tool, right? Like every tool, and the value depends upon the wisdom of the one using it, okay? And throughout this section, we've examined how obligations are created, how they're priced, how they're documented, how they're transferred, and how they're secured, right? And how they're administered when performance becomes difficult, right? And I hope you begun seeing debt a little bit differently, okay? Not as an emotional burden, something to get, to be afraid of, all right? But as a relationship governed by identifiable principles. It's a commercial relationship, okay? And once you understand the principles, fear begins giving way to discernment, being able to make wise decisions in how you operate in the system. If for nothing else, you may, get loans at better terms and save money over the long term, if that's just one thing. But there's a lot more tools than just that. This is just to give you an overview of the fullness of the master course that this is presenting and introducing you guys to. Okay, so when the other side of the commercial equation, right? You have debt, and then you have credit. Go to credit reporting. Okay. So if debt represents obligations, then credit represents confidence or trust. Okay. It's the commercial reputation system. And again, I don't endorse it. I do not think it's the greatest system out there, but it is what it is. Okay. More specifically, a credit report is a commercial record maintained by third parties. It attempts to summarize your borrowing history. Okay, real simple. People, I have some very close family that the credit score is everything, but does not understand it even a little bit. And especially not completely, and it hurts them all the time. And no matter what you say, the principles just don't register. Okay, so a credit report is not reality. Okay, and this is important, guys. It's not a credit report is not reality. It's not your reality. Okay, it is a report about the reality of what has been reported, okay? And some of it may be true, it may be false, it may be accurate, it may be all, okay? Reports can contain errors, they can be incomplete, they can be outdated, okay? And a trustee never confuses the record with the underlying facts, okay? What records show can also tell you as much of what they, you can also learn more on what they don't. Okay, but throughout commerce, documentation is only as reliable as the processes used to create and maintain that documentation. All right, and that's why every administrator, you have to review your records and anything that affects the commercial standing of that. In the Kingdom of Heaven Trust Management System, where we have separation and pass-throughs and legal pass-through trusts that move things from the public to the private. These things, the records and the systems that are there are to keep that reputation an asset. That the legal person's credit report, okay, or credit score can totally benefit your overall estate. Okay, and I'm not going to get too much into that. The course explains that in a lot more detail, but a lot of folks that'll be listening to this seminar may or may not have been exposed to these types of terms, so I don't want to confuse anybody. All right, so the credit reports eventually become something else. All right, it's a mathematical prediction. Okay, how does it work? All right, it's mathematics. It's not morality. Okay, a credit score is one of the most misunderstood numbers in all of commerce. Okay, it isn't a measure of your intelligence. It isn't a measure of your character. It doesn't even measure your worth. Okay, it's just a statistical model designed to estimate risk probability, whether certain obligations are going to be performed according to recorded past behavior. Okay, and that's it. That's all it is. In other words, lenders aren't trying to predict who you are. They're trying to estimate how much risk are they taking by lending to you. Okay, and that's where that credit score comes in. Okay, trustees understand it because they separate identity, who they are, from administration, the estate that they administer. Okay, so your score is not your identity. Okay, it's just one data point used by others, mostly in finance and insurance, and if you're going to rent a place. I mean, yeah, it does cover a lot of areas. A lot of folks use the reporting system to make decisions as to who you are and whether or not they want to have a relationship with you in the first place. Okay, but it's only one data point used. Okay, it's there's usually a lot of other things that go into making decisions for extending credit. Okay, and one of the main things, okay, is payment history. Trust is built through consistency. Okay, if you go and you take a loan out at a local bank, and you pay that loan on time, and you pay double principal, and you pay that loan off ahead of time, ahead of schedule, right? You build a credit history with that bank. That lender will now look at their history with you and go, of course, yeah, you need 10 this time, no problem. Okay, because you built a relationship, more so than what your credit score may or may not say. Anyway, trust is built through consistency. Commerce depends on trust. Can I trust you to pay me back, right? Trust is rarely created by promises. Okay, and that's why trusts are as a piece of paper, okay, is not created by promise, more so intent, and trust is earned by performance. Okay, every payment made according to agreement becomes another piece of evidence demonstrating your reliability. So that's why payment history carries a whole significant weight within the scoring models. So when you look at the different credit reporting agencies and their reporting models, FICO and others, that is usually carries the most weight of when they are going to make a decision as to whether or not they're going to lend to you. Okay. And the principle extends far beyond borrowing. Okay. The same concept governs trusteeship, right? Fiduciary relationships, partnerships, businesses. Consistent performance builds confidence. Confidence expands opportunities. And that's why scripture repeatedly emphasizes faithfulness in little things before greater responsibilities are entrusted. Okay. So those everyday things that add up. Okay. All right. So commerce basically reflects a principle that's always existed, that reliability has value. Okay. If I can trust you to show up when you say you're going to show up, that's valuable to a relationship, right? And so how do obligations, how do you manage your obligations? A lot of people don't. They just fly by the seat of their pants, right? You don't even know what memberships they're paying. And it's out selling you very much of it as right. Let's say you have $1 million of credit that you can have access to, and you're only utilizing 100,000 of that at any given time. You're using 10% of what's available. And then somebody says, you go in and you want a $5 million loan to purchase a commercial building. Okay. Why should, you have very low utilization. You really don't need the money. You could probably get it, no problem, but it affects the terms of the loan you may get. If that makes sense, hopefully it does. But if you're overutilized, when I was doing finance, 40% utilization is high, and that's as high as we would want you to be if we were in the process of trying to get you funding. Okay? Because it shows that you're not in trouble, you're not needy, you're not overextended. Like if we didn't lend you this money, you're going to forfeit next month. They don't want to see that. Utilization is how they figure that out. Okay. One carries a consistent balance, high balances, paying minimal payments, right? And keeping a very high utilization. They're not going to get another offer for a card or an extension of credit, where they change the limit and increase the limits for them, because they're overutilized. They're always flying by the seat of their pants, one emergency away from failure, breach, of the contract. Okay. So when utilization, isn't measuring wealth, it's measuring the available capacity to borrow, that's available to you now. Okay. Trustees, they think similarly. Good administration always preserves the margin. Margin creates flexibility. Okay. If I'm only 10% utilized and I don't get a paycheck this week, I can easily, go over and cover my bills. Okay. Because I have not utilized all that's available to me. Now, again, this is credit. It's not cash flow. It's money that's creating out. It's availability of an obligation that it carries, right? It has to be paid back at a future time, all right? But it does create flexibility, and flexibility creates options. Options reduce risk, and that's why banks and credit card companies always look at utilization. Excuse me. All right. So, all right. The next thing, often surprises people because it isn't about money at all. All right. Applications and inquiries. If we're looking at credit reports, okay, every time you fill out an application and they run your credit report, whether it's a hard or a soft pull on your credit report, the inquiries, right? Every request tells a story, and that's why they're on your credit report, and they stay on your credit reports unless you know how to get them off of your credit report. In the course, I do have, we'll get to that. Never mind. We'll get to that eventually. But every commercial action leaves a trail. Every application, every inquiry, every request for additional credit becomes another piece of commercial data that's in these reports. Okay. And if you view them individually, they don't appear very significant. But when you lump them all together, they definitely start to tell a story. Okay. Commerce, especially financial institutions, always evaluate patterns, not isolated events. Anybody can have an emergency, and that emergency can be explained. You can even explain things on that credit report and make it part of the file and the record. Most folks don't have a clue that they even have that as an option. Okay. There are lots of options if you start to understand how it all works. Okay. So trustees understand that reputation is accumulated through repeated behavior, good or bad, right? So before submitting any application, ask yourself, what objective does it serve? Does it strengthen my commercial position, or am I simply reacting to an emergency, right? Administration means every commercial decision has to have a clearly defined purpose. So going into debt, okay, has to be for a specific purpose. And it's not to go on vacation. It's not to purchase a personal vehicle. Okay. It has to be able to make sense. It's got to pay for itself. The value has to be created with the credit for the thing that you're buying. All right. So a clearly defined purpose, random activity produces random outcomes. Intentional administration produces predictable results. Okay. And not every obligation performs as intended. Okay. So the next question becomes, what happens when an account enters into collections? Right? People dread this stuff. They get the bill in the mail. You're in collections, debts owed, debtors calling. It's a horrible thing. Debt repair, or credit repair is a huge industry. And when you're in finance, you become an expert at fixing people's credits and bolstering people's credit so that they can get the funding and you can actually get paid. So this course I put a lot into because I spent my whole life doing this stuff. So it's not just, something that you're going to find online where you can get practical ways of repairing your debt or building corporate credit or building credit within a trust or a trust estate, or these are not if you're part, they're tricks of the trade. If you're doing these things actively, you may have heard of them before. You may even use some of these tools and principles. Okay, but they're not out there. Most consumers haven't got a clue. Hopefully, after this call, none of you will be consumers just for consumer's sake. So rights continue after default. Okay. Collections are where many people begin making emotional decisions, right, instead of administrative ones. An obligation might be overdue, okay, but that doesn't suspend the rule of law. Okay, creditors have rights, debtors have rights, collection agencies have duties and have to operate within very strict regulations. Or at least they used to. I'm not sure where they're at now, but every participant has and operates within legal boundaries. Okay, that's contractually obligated to because you volunteered for that contract. Okay, so why does that knowledge matter? Okay, before responding to creditors, okay, or to collection agents, verify the obligation, verify the amount, verify the chain of ownership, verify their authority of the party that's trying to make the demand. A lot of credit agents, collection agencies purchased the debt for pennies on the dollar. Okay, they purchased it because the company that you did business with couldn't collect. It may have been, they may have had assignment rights, and anybody could sell the debt, for whatever they want. But maybe based on your contract, not all rights transfer to that collection agency. There's a lot of things that you can look at and analyze when you're trying to defend from some of these types of claims. Okay. But, administration, it always begins with the facts. Fear and emotions makes poor decisions. Okay. Documentation creates clarity. Eventually you begin asking questions or asking different questions. Right. So instead of improving your personal credit, right, and doing things in your legal person, okay, if you're operating in the legal person as a surety for your legal person, then you may want to look into the website and start getting some information about operating separately and set apart, being able to operate that legal entity at arm's length where you are not personally bound to it. These same concepts, were the whole point. I set up corporations for a living. I help people incorporate and structure and plan their businesses. Okay. And the one thing that it was always about was separating the enterprise, the business, the company from any of its owners. Okay. And you operate behind a corporate veil, which provides you with protections. It limits your liability, right? A limited liability corporation. Okay. And that separates me. So my business model was, I'll help you, analyze your industry and make a plan that, around your idea. I'll help you pick the proper structure, pick get the proper insurances to protect protect you. And the whole point was to increase privacy, to separate the legal person or the man or woman from this corporate legal fiction entity. Okay. And it's not just about for separation's sake, but, again, it's just no different. It's an entity. It's just like any other business. It has a corporate identity. People will either trust it or not trust it, right? They'll either have a good experience with that business or not so good experience, right? And it's the same so setting up business credit. I used to actually teach it and created a whole system for setting up and building business credit over the years, and separating the enterprise from the individual, whether this is a trust or some other corporate structure. The entity itself should have its own financial reputation and its own ability to utilize debt and credit tools without making the principal stockholders or members liable as surety for the corporate debts. Okay, so businesses develop commercial reputations just like people, right? They establish trade relationships, build payment histories, create documented performance independent of the owners or individuals behind the company. Okay, and this is one reason I learned very early to operate at arm's length and away from many of the systems of this world. You can still be in the world and not be of the world, and utilizing business credit, building a separate trust or a separate identity that you utilize as an interface when you're dealing with the public, so that you never touch the unclean thing, so to say. All right, so commerce functions best when everybody occupies the proper role. We talk about this in trust all the time. Good structure doesn't eliminate responsibility, but it organizes the responsibility, right? And regardless of whether you're administrating your personal or your business credit, there's one thing every lender absolutely watches. Okay, you can have a great credit score, but if you have no way to service that debt with cash flow, you are on the brink of bankruptcy. Okay? Lenders want to know, where's the money coming in, where is it going, and how much is left over to pay us. Okay? Assets are real impressive. Net worth attracts attention. But cash is king, and in commerce, cash flow keeps obligations alive. Right? We've been talking about obligations. Well, this is how obligations are paid, cash flow. Okay? Every enterprise survives on movement. Money comes in, obligations go out, surpluses remain. That's cash flow. Okay? Modern fiat currency itself possesses zero intrinsic value. Okay? Its usefulness comes from confidence, trust, circulation, and the acceptance of it within the system. Right? People stop accepting it because they don't trust that it's worth anything, that the government isn't going to ever pay their debts, and the whole thing fails. And you go back in every empire throughout time has found that to be true. Okay? So the same principle applies to every enterprise, every business, okay? Stagnation creates weakness. Healthy movement creates strength, like a difference between a stagnant pond and a running creek, right? One's going to have life, and the other one's going to have bugs, parasites, and other things growing in it. So trustees monitor flow continuously because liquidity provides flexibility. If you've got cash flow, we could talk about real property, and then you can talk about gold and silver, a little bit more portable, right? Liquidity provides flexibility. Businesses rarely fail because they lacked ideas. They fail because they ran out of operating capital. Cash flow stopped. Okay? So when you begin realizing that every commercial relationship is negotiable, okay, you start to utilize administration through your agreements ahead of time. Okay? Negotiation doesn't have to be a settlement negotiation. You're much better off negotiating and taking that time up front to negotiate terms that works for everybody and protections that work for everybody. Okay? Long before anybody even sits down at the table to agree. Okay? The strongest negotiator is the one who understands the documents, understands the risks, understands the incentives, and understands what each party actually needs. Okay? Because if you can figure out what everybody needs, you can actually draft a win-win contract that protects and benefits the parties to it. All right, and a lot of that has to do with smart administration. All right, every commercial agreement represents an allocation of risks, responsibility, and benefit. Right, and you don't negotiate from emotion. You negotiate from preparation. Knowledge doesn't guarantee a better outcome, but ignorance definitely guarantees a poorer outcome. So even if you are a good negotiator, okay, you're going to encounter setbacks at some point. They used to say in business, it's not about if you're going to be sued at some point in business. It's about when. And it does happen all the time. People get sued for the littlest of things that you don't even think about in business. Okay, it's another reason it's very adversarial, the remedies, but we're not going to get into that tonight. Okay, but I do want to get into recovery. All right, yeah, if you do fail, and we all do. Okay, it's the nice thing about learning from our mistakes. Okay, we can learn to recover and come back stronger. Failure is information. Okay, and you see successful people. They failed more than unsuccessful people. Most unsuccessful people just never try. Okay, successful people fail over and over and over and over again. You've probably witnessed that yourselves. All right. But everybody has signed bad agreements. I'm not even going to get into that either. But even a very current personal situation, I signed a bad agreement. It wasn't because I wanted to, but the timing required it. So, you end up in bad situations sometimes, and you may not have trusted the wrong, you might have trusted the wrong people, or you didn't judge the risk correctly, or, we all learn expensive lessons that way. We've been taken, we trusted someone we shouldn't have, right? It's not the difference of whether failure occurs. It's whether you learn from it and actually can, you can recover from it. Okay. And recovery, from a trust standpoint, is an administrative process. Okay. You review the facts, you identify what happened, the error. You correct the system and fix it, right? That contract that you wrote day one of your company from 5 years in, right? You correct the system. You document the lesson. So the next steward or the next trustee or the next employee can learn the lesson, not the hard way, but because you've already went through it. Okay. And every lesson becomes another building block. Okay. It's not the absence, mastery isn't the absence of mistakes. All right. Mastery is refusing to waste the mistakes by not looking at them as an investment in your education. My father used to tell me, he says, learn to trust somebody. It's a great, lend them $20, and if they ask you, lend them $20 or whatever, 20, 100, it doesn't matter what it is. And if they come back and pay you, that's one step closer to being trusted, right? And if they don't come back, you just learned a very cheap lesson, because their presence will continue to pull from you over and over and over again. So 100 lesson to, that not to trust that person with $100 again, or anything maybe, right? So now we got to move beyond credit and into something a whole lot larger, all right? And that is commercial paper. Okay, commercial paper literally is the language of commerce. Okay, it moves the whole economy. It incorporates not just the fiat system of currency, credit, debt, And all of these principles and subjects that we've been discussing so far tonight. Okay. Commercial paper. So we've looked at individual concepts, and now we're going to look at the language that ties the whole commercial system together. Commercial paper. Okay. It's not simply paperwork, but it's the written evidence of commercial relationships. It's a multi-billion-dollar a year cottage market selling commercial paper, buying commercial paper at discounts and selling it for prime, and all kinds of businesses revolve around that commercial paper. So every invoice, in finance, we would lend against invoices, promissory notes, security agreements, bills of lading, warehouse receipts, every single negotiable instrument that exists. It exists because commerce requires certainty between people who may never even meet. Okay, we think money moves commerce, and in reality, it's the documentation, the evidence of that moves it. Okay, the value a lot of times never moves anywhere, if there's any at all. So documentation moves commerce. Fiat currency merely just serves as one medium of exchange in a much larger documentary system. The system is accounting, guys, financial accounting, accounting principles. Studying law, you look at accounting principles as well, especially if you're dealing with commercial law, okay, international law, admiralty law, okay. The paper defines the relationship. The contract defines the relationship. Signatures establish responsibility and evidence of voluntary interaction, right? The record preserves rights. And if you cannot read the paper, someone else is going to administer your relationship for you. So once commercial rights exist, they have to be transferred, right? And some people that have, have a home and may have had different servicers for their mortgage note, right? They get assigned from one lender to another, or from a lender to a servicing company, or that type of a relationship. So rights can be transferred. Those rights and responsibilities need to be understood, right? Commerce would stop if every obligation remained permanently attached to its original parties. Rights are routinely transferred. Mortgages are assigned, notes are sold, accounts receivable are purchased, contracts change hands, entire businesses are acquired. Assignment is what legally carries those rights from one holder to another. Not every assignment, every assignment creates an important administrative question. Was the transfer actually completed? Was it properly documented? Can the current claimant prove the chain of title? Trustees learn to ask these questions before assuming someone possesses authority simply because they make a demand. All right? Anybody could walk up and say, here, I got this piece of paper that says you owe me $1 million, and put it into a court as a claim. It happens all the time. Quiet title actions and other things similar, right? Rights flow through evidence, not assumptions, right? What are those things about assumptions? All right, so when documentation becomes the foundation, preparation becomes your greatest protection. Documentation. So again, going through this, it's how you plan and prep and are prepared ahead of time that matters. Okay, administration begins long before there's ever going to be a court battle. Most cases are won or lost long before anybody enters even a courtroom. A lot of times, an administrative process can get you the remedy or the solution or the settlement that everybody would prefer equitably, right? So courts primarily evaluate evidence, they examine documents, they review timelines, they compare records, They evaluate credibility, right? And that means the administration begins the day the relationship begins, not the day litigation starts. And unprepared folks or folks ignorant of this system of commerce can easily find themselves learning all about it the day that they get notified that they're being sued, right? And then they're rushing to try and find a remedy because a lawyer's help may be out of touch and probably not wanted. Sorry, I didn't say that out loud, did I? All right, so every email, every agreement, every notice, every ledger, every communication, every modification, every receipt, it all becomes part of the commercial history, okay? It's one reason I emphasized administration throughout this whole call, this whole seminar. Good administration, it frequently prevents disputes from happening in the first place. And when disputes do arise, it gives you something far more valuable than just opinions. All right, it gives you evidence. All right, preparation creates something else as well. It creates leverage. So most people spend their entire lives trying to strengthen their personal credit file, professional trustees. They think a whole lot different than that. Okay. They ask how to build commercial capacity. How can I build my capacity or my entity's capacity to grow? Okay. As a trust or an estate, we're supposed to protect and defend the things that are there and grow the estate, right? Not just protect it, not just put our talents in the ground and hide them, all right? But to manage them and smartly, analyzing every risk, invest in things to expand the estate. So growth, okay, is something that needs to be treated in a way that is intentional, okay? A professional trustee asks how to build that commercial capacity. Properly administered entities can establish their own commercial history. If you do it right, your own banking relationships, their own trade lines, their own borrowing capacity. All right. It's not about escaping responsibility. It's about assigning responsibility to the proper legal and commercial participants. And if you've listened to my podcasts on how to win in court without a liar or any of my calls over the last few years, I speak about, capacity quite a bit. Okay. So, separation creates clarity. Clarity creates confidence. Confidence attracts capital. And that principle, okay, has been so true throughout my whole commercial life in corporate finance and business. Okay, it rings true. If you don't need it, the bank will lend it to you. If you absolutely need it or you're going to starve or go bankrupt, your mom's not going to lend you money. And that's just because they don't have any confidence that you'll ever do what you say. So eventually the experiences are what evolved into the overall Kingdom of Heaven trust management system, right? But so once commercial capacity exists, negotiations become a completely different conversation. Okay. Commercial negotiation, okay. Knowledge is leverage. People believe negotiation is about persuading them, the other party to do what you want. It's not. Negotiation is about alternatives. It's about working out a win-win situation. Okay, because I don't want to do any business with anybody. I would have a hard time trusting somebody whose intention going in to a negotiation was to get an unfair advantage that, over me. If you walked away from the negotiating table feeling like you just got screwed, or taken advantage of, tricked, conned into the contract, part of it would be your own fault for not really analyzing it well. But the feeling wouldn't be, nobody likes that feeling of being taken advantage of. So why would you enter into a contract or any type of negotiation where all parties, should win, all parties should benefit, and all parties should have, responsibilities and duties to the other parties? That's how a win-win contract is negotiated. Okay. So negotiations about alternatives. Whoever possesses the greatest number of legitimate options usually possesses the stronger leverage position. If I don't have to do business with you and can do business with them, and then not just them, but those guys over there and them over there, my leverage goes up because I have options. Documentation creates options. Cash flow creates options. Structure creates options. Knowledge creates options. Trustees negotiate from preparation, not personality. They understand risk. They understand the incentives. They understand commercial interests of every party sitting at the table. All right. And again, the objective is not to defeat the other side. The objective is to reach an agreement that's sustainable because it properly allocates risk, responsibility, and benefit for everybody. Okay. That's administration. And administration is what separates professionals from consuming participants. So, all right. So let's move beyond negotiation and examine how entities themselves become powerful participants in commerce. Okay. We talked about separating yourself from the entity and being able to do that and create that corporate credit that we spoke about earlier, right, is entity borrowing, leveraging the structure, not the individual, not the owner of the business or the manager of the business, member, right, shareholder. So one of the greatest misunderstandings in commerce is that believing that borrowing and liability have always got to belong to the individual, that there has to be a personal guarantor. There doesn't. And throughout commercial history, enterprises have borrowed, invested, purchased, expanded, and developed using properly structured entities. And the legal person is an entity. It's just not a very protected entity, unless you do other things to protect that legal person, which is the entity that you operate in when you have no either corporate structure or trust structure protecting you, that legal person, or you, the surety for it. Again, another seminar. I don't want to get off course. We're getting close. And then we'll come to the section for questions. So, I spent years studying how sophisticated organizations operate. I follow and look and reverse engineer systems, and they rarely conduct commerce through individuals, if at all. They operate through carefully administered entities, lots of them sometimes. The professional trustee asks a whole different question. Who should properly be entering this transaction? Who should be entering the transaction? Structure, it's not paperwork. Structure is a strategy, okay? And when entities are properly administrated and properly structured, they develop something a whole lot more valuable than assets. Reputation. It is a commercial asset for sure, okay? You are only as good as your reputation. That is whether it's personal or public, okay? And the word always talks about to guard your reputation. Not to be untruthful, but to guard it, okay? Commercial strength's not measured simply by how much you own. It's measured by whether other people trust you to perform. If they can't trust you, you won't be getting phone calls. You'll have your little, sign outside, but you won't have business for very long if people don't trust you. Strong entities develop consistent documentation, strong payment histories, strong relationships, internal systems, strong governance. Okay. And those characteristics become the commercial capital. All right. Every fulfilled agreement increases credibility. Every broken promise weakens it. That simple. Commerce runs on confidence. Fiat currency itself literally only functions because people continue to accept it. All it would take was, just a tipping point, lack of trust in the currency, and that currency is the next one you'll be sweeping off the street. Okay? Same principles apply to every enterprise. Confidence produces opportunities. If people trust you, they will do business with you. Okay? Trustees build confidence deliberately because their reputation compounds just like capital. Right? And eventually the objective becomes larger than building one successful enterprise. You may have a conglomerate. Oops, go too far here. Hold on. There we go. Legacy planning. Building systems that outlive you. This is one of the, Kingdom of Heaven Trust Management System is designed to help you build a legacy that outlives you, to be able to pass on systems and assets and things that will manage those for generations if done properly, structured properly, and administrated properly. So most people think about inheritances as the transfers of property, right? Trustees think about it, the transfer of stewardship, right? Money without wisdom doesn't go very long, doesn't survive. Assets without administration will disappear. And that's why true legacy planning includes governance, education, succession planning, documentation, and a culture to pass on how to do that to each next generation. Right? The question isn't simply what will I leave behind? The better question is, will those who receive it know how to use it, how to administrate it? Every generation becomes either a faithful steward or a careless consumer. Think about your own lives. What did your parents teach us? What did our parents teach us? Right? How long did it take before we could figure, these things out, find truth? Because we had no example, right? We come into the world where our inheritance was squandered, right? The knowledge that their parents and their parents' parents should have left were, disappeared. So seeing the whole entire commercial system, right? It's not about memorizing thousands of rules, or it's seeing how it all connects: debt, credit, contracts, negotiable instruments, documentation, risk, governance, entities, administration. None of those things stand alone. They function as one integrated commercial system. This took me decades of study. A bunch of practical application and continual refining of what I believe to be true of this system, right? And it's not just, the Kingdom of Heaven Trust Management System. It's not just a collection of lessons, right? It's an attempt to organize the principles of stewardship, administration, commerce, and law all into one coherent framework, okay? A system, so that you can see all of the isolated parts, where they go in the big picture. Okay? So where does that leave us? So, we examined a whole bunch of stuff. But if you only remember one thing, commerce, let it be this, that commerce is administrated, debt is administered and administrated, and that credit is administrated and administered, okay? Trusts, businesses, estates, wealth, it's all administrated, okay? And administered properly if you want to keep it, and by consuming it, it'll be gone. there won't be anything left for the next generation. And usually, illiteracy, financial illiteracy, and being ignorant of the system, okay, can cost you way, 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 way more than even if it only costs you your future, right? That would be bad enough. But if your children and your children's children, this is why when you look at the fiat system of this world and the debt clocks of each country, right? And you can see the slavery there. It is a system of adversarial proceedings that require documentation. I'm getting a little off course here, but you understand what I mean. And again, everything that I'm trying to build up to here, right, is designed to have you look at the system differently, ask different questions when you're dealing in commerce than maybe you've been asking throughout your lifetime, to hopefully get you a better result, and definitely to allow you to make better decisions and get a better understanding. Okay. And systems are what create predictable results. One of the things that I've been very big on over the years is creating organizational systems. How do things work, and how can I get them to work better? So when I put together these courses, I really do try to give you all of the tools that you would need to operate either successfully in commerce, business, private trust, public trust, whether it be law or administration, defending or doing the day-to-day record keeping. I try to provide all of the tools that you would need as a complete holistic system, not here's this tool and you still need to fill your toolbox with 100 other things. So when I talk about commerce, this program, I start out with what I see as a complete system for being able to analyze and administrate and protect and defend and to fix credit or to build credit, and everything that I remembered to put in the time that I was creating it. The nice thing is it's a community. When you do get the courses, it's a lifetime course. You have access to the materials, and just like that contract that grows over the years, I'm hoping that these courses will grow. I know they will. They already do, just because we have interactive conversations with students that that expands the dialogue and the content pretty much every time we all we get together. So, but I appreciate that. All right, so documentation. Okay, operational documentation is the engine behind this system. Okay, policies, procedures, operating agreements, resolutions, governance manuals. Okay, they're not just bureaucratic paperwork. They're written memory of the organization. All right, they ensure that tomorrow's decisions are governed by today's principles rather than today's emotions. Every mature institution eventually discovers the same truth. People will come and go, systems endure. Okay? One of the reasons I spent all these time developing this was I wasn't interested in building, some personality-driven movement. I could care less about any of that, okay? I wanted to build a system that is simple enough to be understood by almost anyone and applied and improved and eventually administrated by others. Okay, if your organization depends entirely upon one person, you haven't built an institution. You built a dependency for yourself. Okay, if something happens to you, the whole system disappears. So trustees, they build systems. Good systems only remain valuable if they operate with integrity and accountability. That's why, in the private, responsible, in ownership has responsibility. Fiduciary, a trusteeship has responsibilities, duties. Debtor, creditor, both have duties and responsibilities. Okay. And compliance and disclosure, integrity creates that confidence. Okay. Most folks think compliance is something that is not. Okay. I've got to comply. I am horrible at, complying with authorities or so-called authorities. Not been my strong point over my lifetime. Okay. But I get it. Most people hear the word and immediately think of government regulation. And I can understand how that works. But compliance is a whole lot broader subject than just that. Okay. Every agreement creates obligations. Every trust creates duties. Every contract establishes expectations. Compliance simply means faithfully administrating the obligations that you voluntarily accepted. Okay. And disclosure works the same way. You disclose what the relationship requires. You protect what the relationship does not require. Okay. Wisdom is knowing the difference. So oversharing can be just as damaging as concealing information. Right? A good trustee learns how to operate transparently within a relationship while protecting information entrusted to their care. Okay? Excuse me. Integrity is not just an ethical virtue. Okay? It is commercial capital, since we're talking about commerce. So even the best administrators eventually encounter uncertainty, different types of uncertainty. And that's why every system requires some sort of risk management. Okay. Risk management is not, something that you wait to do until something happens, right? It's ahead of time, right? Risks are always there. You walk out your front door, you've got lots of risks. Okay. Risks never eliminated. It can be understood, it can be measured, and it can be managed. And when you manage risk, fear usually dissipates as well. Okay? Every decision creates opportunity. Every opportunity introduces risk of some sort. Okay? And a trustee's responsibility is not to avoid every risk, but to distinguish acceptable risk from unnecessary risk. Okay? Mature administrators constantly ask, what could go wrong? What would the consequences be? How likely is it to happen? What controls already exist? How quickly could we recover if something does go wrong? And that mindset transforms uncertainty into actual administration, an ability to perform, right? Risk management is not pessimism. Okay, it's disciplined stewardship. And the better prepared you are, the less often you're really forced to react in the moment to anything. You see things afar off, So preparation doesn't eliminate conflict, but it does change how we resolve conflict. All right. So administration before litigation. Talk about this all the time. Conflicts are inevitable. Litigation is optional. Litigation, adversarial proceedings are not required. Okay? There's lots of ways to settle disputes. Mature administrators understand that lawsuits are usually evidence that administration failed somewhere earlier in the relationship. And that doesn't mean litigation is not necessary. Okay? Sometimes you have to defend your rights or the rights that you were entrusted with, right? The capacities and rights that you're protected or defending. But before reaching that point, all right, a professional trustee asks, has communication been exhausted? Has negotiation been attempted? Has mediation been considered? Has every document been reviewed? Has every commercial remedy been explored? Okay. Courts generally resolve disputes after relationships broke down. Okay? A trustee attempts to preserve relationships whenever lawful and practical. Okay? Or equitable. Peace is achieved through wisdom and justice is always less expensive than prolonged conflict. Okay? Going in and tripping over $1 million because, on principle, it may not be the wisest thing to do. Okay? Peace, when achieved through wisdom and justice, is always less expensive than prolonged conflict. So ultimately, every successful institution faces one unavoidable question: what happens after we're gone? All right, succession planning, preparing for the next steward or the next trustee, the next CEO or the next boss, right? Every organization eventually changes hands. Every trustee is temporary. Every administrator is eventually replaced. The only question is whether that transition is intentional or chaotic. Succession planning is not simply choosing a successor. It is transferring knowledge, authority, documentation, culture, and responsibility in an orderly manner. Okay? Throughout history, great institutions have rarely failed because they lacked resources. They failed because they failed to prepare the next generation of leadership. I think entire civilizations rise and fall on that same problem. And a faithful steward measures success not only by what he builds, but what continues after they're gone. Legacy begins with succession. Stewardship is never about us. It's about faithfully preparing those who come after us. So, confidentiality and privacy. I said earlier that, separating a person from the entity itself creates a much higher level of confidentiality and privacy, personal privacy, especially. But trust is built on proper stewardship of information, okay? Information has been one of the most valuable assets in commerce. And long before the digital age, merchants guarded their accounts, their ledgers, right? Trustees protected beneficiary records. Bankers secure account books. Families preserve private correspondence, right? They kept family, important family information in a record in their Bibles, in their family Bibles or ledgers, okay? A professional trustee understands that not every fact belongs in every conversation. Confidentiality is not secrecy. It's the disciplined administration of information, okay? And it's according to the relationship that created it. When people go, what's the best thing or the best way to keep your affairs private? Shut up. Because information gets out there because somebody within the entity is talking about it. And it's not rude to say, I am not at liberty to share that information with you unless you're party to the trust that holds it. Works out well in legal situations quite often. So confidentiality is not secrecy. It's administration of the information, okay? Some information belongs to beneficiaries. Some belongs to trustees. Some belongs only within privileged relationships. And wisdom is knowing how to, what the difference is. A careless administrator loses documents. A faithful steward protects what's been entrusted to their care. So protecting information is only one part of integrity, and the other part is protecting your own character. Here's something you rarely even would associate with commerce a lot of the times, the way that it is done today. character is a commercial asset, and every commercial system eventually reaches the same limitations. Documents cannot replace character. Documents also cannot replace knowledge and get you a remedy just because you have a document. If you don't understand it or what the purpose or intent is or how to use it, it's not going to help you very much. We talk about that all the time. So regulations don't force wisdom. They don't even force compliance. Okay? They can only respond after character has already failed. Okay? And that's why ethical leadership remains one of the greatest competitive advantages any trustee or business would possess. Okay? Your reputation becomes part of every negotiation before you ever even enter the room. People remember whether you were honored your agreements or whether your word carries weight, right? Whether you acted fairly when no one can compel you to, commercial success could build wealth, okay? Character determines whether that wealth survives. Stewardship begins long before signatures. It begins in the heart of the administrator. Oops. You get into a couple other things here. Here we go. There we go. Key person protection, talking insurance. One question separates mature organizations from a fragile one. Right? What happens if our most important person is suddenly unavailable? Every institution eventually experiences these transitions: illness, disability, retirement, death, unexpected change, right? And as a professional trustee, you prepare for those realities long before they become emergencies. Again, preparation. Knowing ahead of time how to avoid the problem is way cheaper than learning in the hot seat. Okay. Knowledge has to be documented, authority has to be delegated, successors must be developed, insurance, continuity plans, and governing structures are tools that preserve that mission beyond any single individual. And if one person's absence destroys the organization was never properly built. Okay? As organizations mature, technology becomes another thing that needs stewarding, and which is why I included it in this seminar. All right. Technology should multiply wisdom, not replace it. If you're using AI, you should know that right up front. Right. Technology is one of the greatest force multipliers available these days. It allows you to do things that we couldn't do a year ago, 2 years ago, 5 years ago. Okay. The ability to organize information, automate routine tasks, protect records, improve communication, right? Create accountability, all right? But it's still only a servant, and it should definitely not become the master. AI, automation, cloud systems, digital records, they all increase efficiency, okay? But you can't let them replace your own judgment, your own discernment, and none of them will replace your fiduciary responsibilities. Okay, a poor administrator with better software still is a poor administrator. A wise person with technology, okay, will strengthen their stewardship, not substitute it. Okay. Oh boy, guys, we're getting to the end here. Continuous improvement. Okay, mastery is never finished. There's always something new to learn. Okay, every agreement teaches us something. Every mistake reveals something. Every success uncovers a better question. So every commercial right ultimately depends upon, can you prove it? Okay. Memory is not the evidence. Assumptions are not evidence. Opinions are not evidence. Evidence, right? Documentation, facts, that's evidence. Professional trustees build systems that preserve records long after memories disappear. They write agreements, correspondence, receipts, ledgers, resolutions, minutes, assignments. Every single document becomes another piece of evidence supporting their administration. Okay? Poorly documented estate is vulnerable. Well-documented estate becomes difficult to challenge. Okay? And good administration is built one record at a time. Each individual record matters. Okay? But understanding how they all fit together, that matters even more. And again, this is back to the systems thinking. You know, it's something that it makes us capable of doing big things without having to do all these things all at once. Okay, so having a system mindset. What can I do? What can I put in place today that's going to make my life easier administrating in the future? How do I organize my data, my policies, the relationships, the technology, all of these separate individual things? How do they all fit together, and how can I create a system that allows me to organize and practically utilize that, the system that's organizing your estate or your finances or your business or your marriage, or, pick a structure that, that requires management and administration, and systems will make that much, much easier to accomplish. Anybody that knows me knows that taxes are not something that I'm going to keep that one to myself. Anyway, tax strategy and planning. Structure determines administration. If you're properly structured, you can mitigate taxes down to a minimum, if not eliminate them completely, even if it's just for a time. Okay, and trusts have been used as tax strategies for folks for many millennia, and it's the same thing today. Businesses and business structures, trust structures will help determine whether or not you will even owe. Okay, but taxes generate more emotions than almost any other commercial subject. Okay, professional trustee begins somewhere different. Okay, we begin with structure. Okay, every jurisdiction, every authority administers according to its own rules. Those rules apply according to the relationships between them, the activities, the capacities, and the documented facts. Good planning, therefore, begins long before a return is ever prepared or even contemplated. Okay, it begins with properly identifying the parties, properly documenting authority, maintaining separate records, respecting the boundaries between private administration and public interfaces. Excuse me. The goal is not confusion. The goal is clarity. Structure first, administration second, reporting follows administration, and the better the administration, the simpler the reporting becomes, if there's any duty to report in the first place. Okay? And again, I'm not going to get into that now. Tax strategies and things like that, how to deal with these things from the Kingdom of Heaven Trust Management System. I go into quite a bit in a lot of other recordings and courses as well. So this is just an overview, guys. All right. Moving on to insurance and transferring risks before, loss occurs. Okay. You want to prevent loss. Insurance is not necessarily an investment. Okay. But it is one way of transferring financial risk. All right. Every trust, every business, every trustee eventually confronts that uncertainty. Fire, floods, lawsuits, disability, death, business interruptions, right? The question is never whether a risk exists. It's whether it's really who's gonna be the one bearing the risk. Who's got that burden? So insurance becomes one of several tools that allows trustees to preserve assets while continuing the mission of the estate. Works the same in business, also works the same in parallel in your personal life, okay? Whether it be your family or other personal relationships, okay? Insurance can mitigate and or remove risk. Well, not necessarily remove it, but it'll definitely mitigate the liabilities of that risk. Okay. Just trying to move it on a little bit here, guys. Estate and wealth preservation, thinking beyond your lifetime. Most people spend their entire lives learning how to accumulate wealth. Very far fewer learn how to preserve it. And preservation begins with the simple realization that wealth is temporary. Stewardship has to be generational. Buildings will decay, markets fluctuate, currencies change, governments change, laws change. Disciplined administration allows one generation to transfer opportunity to the next. That's simple. It protects tomorrow's possibilities, and legacy is not measured by what you accumulated, okay? It's measured by what continues after you're gone, okay? So what is wealth actually for? So one of the greatest errors I found in commerce is believing that wealth is the end all. It's the end place. It's the goal, right? The objective. Wealth has never been the objective. It's a tool, right? People get really twisted when that wealth is the objective for greed for greed's sake. It's just not a nice place to live. It's not a nice way to live. It's a tool, right? Tools exist to accomplish purposes beyond themselves. So throughout history, civilizations have been measured not by what they've accumulated, but by what they built, preserved, and passed forward. So kingdom stewardship asks a whole different question than most modern finance. Right? It doesn't ask how much can I keep, how much can I amass. It asks what's been entrusted to me and how can I administer it faithfully. Right? Commerce becomes meaningful when it serves families, communities, productive business, and future generations. So money without purpose eventually controls the owner. Purpose gives wealth direction. Stewardship gives it lasting impact. And, no system though is going to be designed, however well designed, can compensate for a poor character, somebody with, no integrity. So that is greed and integrity have a lot to do with your character and how you're viewed in commerce, for sure. Okay. The greatest asset is the self, right? The greatest weakness in any trust is not the documents. It's the trustee. Every commercial structure ultimately reflects the discipline of the person administrating it. Okay. Every country, the same thing. Every business, the same thing. Okay. Knowledge without discipline produces inconsistency. Discipline without wisdom becomes rigidity, and wisdom without integrity eventually collapses under the temptation. So before you can administer your estates, your businesses, your organizations, you first have to learn to administer yourself. Guard your habits, your emotions, your reputation, and your word. Commerce rewards consistency far more often than brilliance. There's a lot of brilliant, broke people out there, for sure. Okay? Professional trustees are trusted because they first become trustworthy. Okay? No serious trustee succeeds by themselves. Okay? They depend on the ones that are around them, right? Building a team of experts that you can trust, right? One of the myths of leadership is that you have to answer you have to have the answers to everything yourself. And if you have, if you're wearing all the hats within your organization, then, you may have to answer everything yourself. It's not the best place to be, though, because if you have a team that you could depend on, successors, trustees and people that you train to take your place, right? Accountants understand accounting. A lawyer may understand litigation, right? Financial professionals understand capital. Insurance, trustees. A trustee can be a good coordinator and should have a good foundational knowledge of all of those things. Because otherwise, you're just taking somebody's word for it as an authority. And that, again, could cost you in commerce especially. Okay? So leadership's not doing everybody's job. It's understanding enough about each discipline to recognize sound advice, ask better questions, and make informed decisions. Humility is not weakness. It's recognizing that wisdom grows faster through collaboration than through isolation. Okay? All right. So, putting the whole thing together. Okay. Throughout the last slides, we've been assembling something a whole lot larger than just isolated concepts. We looked at debt, credit, negotiable instruments, documentation, administration, commercial structures, the law, risk management, leadership, stewardship, right? And none of those subjects stand alone. They form an integrated administrative framework. Knowledge becomes valuable only when it consistently produces better decisions. Okay, and that's the difference between education and mastery. So my objective has never been to just know more. Okay, that's like being a dumpster for information. Okay, it's purposeful information. Okay, that makes us become more capable of administering more things in our lives. Right, be faithful in the little, and more will be added. Okay. So as today's seminar ends, this is really just the beginning. Okay. Keep growing, keep building. Okay. Every problem you solve is another lesson. Okay. And I just wanted to let you know that this course and this seminar will be on the website. A recording of this will be on there if you want to share with friends, family. If you think that it's been a benefit or had value to you, I hope it has, that you share that with those that you feel would benefit from it. Okay. Now that you have a map, okay, these are not isolated facts, not just internet theories, but a real framework. You should understand debt and credit and negotiable instruments, hopefully in a way that you may not have before. Okay. So just wanted to end this with an invite. Okay. We are building a community of students that are learning to steward together and learn and study together and to grow. And, these relationships, again, can become an asset in your arsenal. Okay. I am offering a 30-day, no risk, no obligation access to the Exploring Foundations membership. Gives you full access to the website, not to the courses, but to a lot of information, a lot of free articles and educational resources. Okay, that's at bulletproofsolutions.org. Okay, You can use that 30 days to learn these systems, apply these principles, build your plans, ask hard questions, whether it be of me or the other students in the courses. Gives you a good understanding of what it is that I'm trying to convey in these teachings before you ever commit to being a part of it, becoming a student. Also, giving a $1,000 discount offer until the end of July 31st, $1,000 off the Hidden World of Commerce Master Course. And again, it is good until July 31st, 2026, not 2025. But this is what you will get in that course. There is 100 core lessons, okay? Gives you a full foundation. And then there's a bonus section that is for credit repair and corporate credit building, okay? It not only just gives you the information, but it is a full, complete system along with templates and examples and case studies and practical application that you can utilize to fix your financial past, build a financial future. And again, this is not a beginner level course. It is set up so that you can start from the beginning and learn, but it is I would say this is at least a master's level course in commerce and the world of commerce, business structuring, business funding, entity structuring, private commerce versus public commerce, and a lot of these other ideas and principles are part of the full course. Okay? This course is for individuals, business owners, trustees and stewards, professionals, okay? Anybody who is, been running in debt cycles that don't benefit them, maybe harming you and your family. That's who this course is for, okay? The credit repair section in this course has been used very practically in the professional area of credit repair over the course of the better part of 30 years. So I'm sure there are credit repair agencies out there that don't want this information in the hands of just anybody, but I don't believe in withholding tools from people who are trying to administrate their lives better. So you can make a decision to come and check out some of the other educational materials, tons of articles, other seminars at the website. I do pray this training has equipped you to see things a little more clearly and act more strategically and operate in commerce with confidence. Okay. And bulletproofsolutions.org, you can go there. You can sign up for the 30-day free membership, the Exploring Foundations membership. You can sign up for the courses, any of the courses that are there. Also, we do also extend credit for some of these courses as well. So all of those options are at bulletproofsolutions.org. And on that note, I am going to open this up to questions. Anybody have any questions they'd like to discuss or ask? I know it's been a long, long presentation, guys, and I apologize. I didn't expect it to go on so long. Anybody have any questions or comments they'd like to ask? Now's the time.
Hi, David. This is Valerie. Thanks so much. This has actually answered a lot of the questions that I've had about legacy, and I've been asking questions like, because I'm not a hugely materialistic woman, but I know that it's important to leave a legacy, and it's also, I find it really interesting to do business, and a lot of the debt downfalls that you explained, I have experienced them. So, I have firsthand experience, and I know that with knowledge, I didn't have to. So much of it is ringing true to me. And I will be thinking a lot more, but it's inspiring me to finish the first course, to fine tune the first course. So I really appreciate all of this. It's been a wonderful, action-packed presentation, David. Thank you.
Oh, my pleasure. Thank you. I'm glad you're getting into your structuring, and it's so important to build that foundation and having the knowledge ahead of time. You're not the only one. A lot of folks have, it's not something taught in school, and it's on purpose because debt keeps people enslaved to the system. And if people had a clue, if they were taught growing up before they were introduced to these, credit and debt and things like that, and we're able to understand that it's a tool, not an operation manual. It's not a modus operandi. It's not, I need debt or credit so that I can survive, because eventually you have to pay the piper. And that's a real tough pill to swallow when you're 18, 19, 20 years old, and you get, that realization that, those things I obligated myself to 2, 3, 4, 5 years ago is keeping me from buying my first house or buying my car that I can, that doesn't, need work every day. So, it's very important, and I'm glad you're furthering your studies. Anybody else have any questions? Thanks, Valerie. Questions, comments? All right. Well, I do appreciate everybody who stuck around here to the end, and everybody who wasn't able to do so. I am going to get this seminar recording into the website, and it'll be available there for the archive there. You'll be able to review it or share it from there. Again, thank you, everyone, for spending your time this evening with me and allowing me to present this information to you guys.
Thank you, David. It was very intense.
It was longer than I expected.
Yes, and it is a 12:45 at my place. So.
Oh my goodness! Well,
Yes.
Thanks for staying up with me here. All right, guys. Thanks again. Right. Everybody have a fantastic evening.
Yes, you too.
Good night. Thank you.
Good night.